Yes, fine.
May I move I, my lord, after completion of because there is a correction.
I beg to mention item number
94.
Yes. Earlier to us, respect me. The 5 years conviction.
We'll try to take it. No, there may be others also. Just hold on. Keep it open. Keep it open. Oh, sir.
Maybe some.
I'll try to complete the list. So going fast.
May I please, Your Lordship? My lord, item number 39, perhaps diary not received, my lord. Diary আছে না? I am an interim, my lord. Diary not received. So, my
Item
lord, after
39, case diary not received. Issue fresh petition. Interim order, right order date. Interim bail, right order date stands extended. Next date of listing.
Highly.
List on 17.
My lord, similar pair in item number 58, my lord.
58.
58.
Kindly check the microphone. It's not hearing. Allow adjustment.
Then, my lord, I will wait, my lord.
Okay.
39, I will wait.
In 39.
39, perhaps success submitted. Then I will wait, my lord. My lord, similar pair in 58, my lord. Perhaps diary not received, my lord. 58, I think. My lord, I am not in interim, my lord. If possible, my lord, prior vacation will. From Boku Campus.
25 9 City not City.
Hello.
Item number 47. Person city is not there. Interim. 47.
47. Diary not. Wait for it.
May it please your lordship.
Yeah.
I beg to mention item number 67.
67.
Lordship, on the last occasion, the case diary and the medical report was called for. We have received the case diary, but medical report not available in the case diary. So medical report is required for. It's another possible to try to put into medical report.
Are you on interim?
No, lordship. And it is next week.
Case diary received 67. But medical report not yet received. Full stop. The same may be requisition while retaining the case diary. Fixed on 25. 25, 9.
Much of that.
This was item number 67.
67.
May I please, Your Lordship? So with the consent of the other side, I beg to mention item number 14 of the daily list, my lord.
14,
14, 1
1.
Item may come after vacation, my lord. Much obliged, my lord.
John, list after vacation on 22/10. Yeah, 22/10.
Much obliged.
May I please, lordship? Lordship, item number 8. Medically, that's
58,
38.
38. Yes. AB. Interim is there.
Yes, ma'am.
After vacation, 22/10.
May I please, Your Lordship? I beg to mention item number 37. Similar period.
Similar. Diary not received. Similar. 37.
37. Vacation, Lordship. Interim was there, Lordship.
Interim is extended till next step. That is also you fix it on 22nd. Same.
Item number 51, my lord. Metro may approve the table. CD has received last occasion, my lord. 51 of yes. Yes.
What is your plan?
We have received the case there. Next week, then we retain, but otherwise,
Yes, do it then. CBS come. We can wait and see what happens. Otherwise, thereafter, if necessary, we can.
my senior is not appear in the court, my lord. That's why I'm here.
So, you don't want to do. So, fix it next to retaining the same 23rd.
23rd.
Okay,
Obviously.
no problem. Okay, you want it after vacation?
No,
Because interim is not there. Interim is there,
even interim is there, my lord.
but CD will have to send back.
8% of the CD that. I mean, in the city, then after vacation, my lord.
51.
Yes, my lord.
It will not be proper to send back and since CD has got on this one. If we need something, then need something more, then it is different. So let us try on Tuesday. Tuesday.
Obviously, my lord. Every lordship, but I didn't item number 2.
Item number 2.
It's time allowed to do that.
You want to withdraw? Learned counsel say to withdraw the petition. We are allowed. Disposed of on withdraw.
May it please your lordship. In today's daily is item number 5, my lord, we have filed one additional affidavit to bring on record FIR. The same is not.
May please, your lordship. Lordship, I'm praying for upgradation of item number 56. Lordship. Actually, it is a bail getting VA matter.
56.
Yes, lordship.
56. 55 was the case there.
It's connected, right?
Connected. Then
Upgradation. Reaching. We'll have to reach this halfway mark. They did come.
May I please, your lordship. Lordship, I beg to mention item number 48, lordship. CD is not. Okay.
Interim there,
Yes, lordship.
CD not received.
city not.
48. Item 48.
48.
Interim extent. 2310.
Published.
My lordship. Item number 53 and 54 will file IA for implement. When they allow us for negotiation.
Maybe, Sir Lordship. So I am paying for listing one IM for order correction on Monday. Obviously.
I would like to mention item number 88 supplement. But in this case, my lord, in my information, my lord, the charge has been submitted last occasion, instruction was sought for. My learned man said that I think instruction not been, my lord, like, also can it be fixed next week or my lord, after vacation?
Bail hearings, sorry, the case diary has not been received. Interim is there. Same standard. It's on 2310 or 2210.
Yes.
2310.
Please, your lordship. Lordship, regarding item number 42, perhaps case diary is not there.
Object.
They might see the case there.
Not received.
Very time.
There's an interim order.
Interim extent. Fix on 22, 22,
22,
2210. 2210.
Interim may be extended.
Then interim extent.
Item number 43, perhaps charge sheet has been submitted.
The other one was 41.
42 also.
42. CB 1690. Item number 43.
43, my lord, perhaps charge sheet has been accepted.
Should we take up in the sequence?
Well, we dispose it of, there's an interim order, my lord, extend that and I will appear in the trial court in 10 or 15 days.
If you can wait and ask.
My lord, I will wait.
I have to reach
My lord, I'll leave, my lord.
the time.
Pilots. 81, 87 or 91 minus supplementary, but all the series, all material is stopped. So,
After the second half,
Case
diary is there?
they details, I can say,
case there is
one. Second up, probably
Okay.
it will be better.
together. Better.
May it please your lordship. Well, may I take the lordship to the FIR page 8. What happened, madam? Admittedly, there was a relationship between the informant
And both were aged for the petitioner is 35, she is 40 months. Pay rate is the FIR month. And she knew that I am a married man. She was also a married man, a married woman mother. Pay rate, pay rate.
Let's call for the case diary.
Kindly see, mother. She knew, mother, that I'm a married person, mother. So then there was a relationship developed, my lord. Then my relationship turned sour, my lord. And this case, now she has shown an affidavit, mother. That is at page 18, mother. Page 18, mother. Page 18, mother. That the vernacular is at page 20. Page 18, mother. So, mother, keeping this person in custody, mother, because there was a relationship, but turned sour, mother. Then she realized, mother, that everything has been settled, mother. So further custody may not be required.
But this has to be informed, cross-checked. Is she present?
Well, no, my lord, we have annexed it, my lord. But we have submitted the same before the landed CGM also, my lord. But it was not confirmed. I have taken copy, the certified copy. Certified copy. Certified copy, my lord, we have submitted to the landed CGM, my lord. So, my lord, it was not because landed CGM, my lord, rightly said that it is a session tribal case. I cannot show, my lord. It was rejected somewhere before your lordship. So keeping this person in custody, my lord, because she allegedly her date of birth as per the FIR is 1985. So she is 40 years old. The person, she knew, she admitted that he is a married person. So further custody, my lord, may not serve any purpose, my lord.
And I have only one concern, the affidavit,
Well,
can you?
Well, affidavit where we have annexed also, and I produced the certified copy from the CGM, my lord, from the landed CGM. With the certified copy, we have submitted there, but it was not considered.
It was?
It was not because landed CGM stated, my lord, it was a session tribal case, 69, my lord. So, my lord. So we have to put in the document. That original also maybe capture the part of the record money considers, my lord. So, my further custody, my lord. May not
Sam Abdullah Lanet comes. And DP Goswami. The petitioner is seeking regular bail under 483 BNSS. Has filed this petition in connection with Rongya PS case 210 of 25 under so-and-so BNS. Who was arrested on 11/9. Perused Azahar dated 9/9/2025. Allegation pertains to dispute from a relationship. The learned counsel has annexed with the bail petition an affidavit made by the informant stating that the case was lost due to misunderstanding. He has no objection to the bail. A certified copy of the same submitted before the court of the learned CJ, sorry, SDJM Rongya. Yes, we also produced this photo. Shall we get the seat case diary? Huh? Because new match also. Call for the case diary from the concerned police station. However, in the interim, allowed to go on bail of this 20,000 in civil. Object to cooperate with the process of law. It's on
after the
2410.
it will be SDGM wrong, yeah, my
Concerned learned court.
lost. I'm deeply obliged.
You can take this back if you want.
This is regular bail application, Lordship.
Yes.
In this case, Lordship, the petitioner is in custody about 40 days. But apparently, Lordship, and I have gone through the FIR, Lordship, his name is not appearing in the FIR. But subsequently, but in the contents of the FIR, Lordship, one personally, and he was the conductor, Lordship, and the mason. And the petitioner is the helper of mason, helper, and he is by profession mason, Lordship. And some, lordship, when the informant house is looted, Dokaiti lordship, some person lordship involved is their lordship. But right now, lordship, my submission is that lordship, petitioner is a kidney patient, lordship, kindly come to page number 18. He is very severely suffering from, and one kidney already been damaged, lordship, and the right kidney, lordship. And medical issue is here, page number 18, lordship, in the top part, lordship. The subject, intimation regarding arrest and hospitalization of accused person, lordship. And the hospitalization of details, lordship, and para number in middle, lordship. Have you got middle?
Yes.
On 10/8/2025 at about 3 AM, the arrested accused person suddenly complained and uneasiness for which and he was immediately shifted to Guwahati Medical College Hospital so and the Bharagar. Upon medical examination, it was found that the accused is suffering from kidney related health issues, namely right rental and rental calculus and urinary bladder and debris. And the accused is currently admitted for treatment, and upon his discharge from the hospital, and he will be produced before his lordship. So, my lord, and kindly come to next page number, lordship, 21, lordship, also very clearly mentioned. And otherwise, lordship, the other accused person already been arrested, lordship. Some stolen article has been recovered, but nothing has been recovered from my possession. So, my lord, I am not only on merit, lordship, but I am the kidney patient. My health
I will give a direction. Similar bill,
interim protection.
FIR is there, same bail pertaining to the same FIR. Is it fixed? One of the things. Because I've gone through this, the connected bail application. That's I've gone through. I'm familiar with this FIR. Anyway, but I don't remember the date.
My Latin submission, lordship, lordship.
The council and call for the case diary of Chanmari Police PS case 195 of 25 under section so and so. The allegation in the Azhar dated 28/7/2025 pertains to dacoity in the house of the informant by a gang. Used was call for the case diary further in view of the projected kidney ailment of the accused. The learned jail authority is directed to continue providing him proper treatment. Inform the concern. Inform the concern. List 24/9. It's fixed. It's fixed. It's 24/9. Go ahead.
Non-active.
Oh, 7%. It's beer. It's a submission.
Call for report.
Report. From Borpeta, please.
Yes.
Your name?
Yes, please.
Stop. The petitioner hearing is filed this petition, apprehending arrest, but does not have details, specific details of any PS case. Call for a report from Borpeta Police Station. As to whether any FIR lodged against him or any case registered in the said police station. List on. You know, manage everything. next week. This Tom,
25,
25-10,
25,
25-9.
In anticipatory bail application. So, case involving, my lord, a fight between family members who have been feuding over a property matter. The lordship will find the FIR at page 12.
12.
May I read the FIR?
5 petitioners, right?
5 petitions.
Let's go. You like to read?
Yes, ma'am. Lordship has placed.
Yes.
Sir, with due respect, I would like to state that on 12 May 2025, at around 10:30 a.m., while my father Zohirul Islam, my brother Shamsul Alam, and my uncle Mustafa Sheikh were working on our land situated at Rangapani, the accused persons named below with the intent to kill attacked them with sharp weapons such as Bosurpi, dao, iron rod, etc., inflicting blows on their heads, various parts of their bodies and feet, thereby attempting to kill them and causing grievous injuries. Thereafter, the injured persons were taken to Mankachar CHC, where they received initial medical treatment, and subsequently the attending doctor referred my father to GMCH, Guwahati, for further treatment. Now, your lordship will find the names of the accused in the next page, my lord. 1, 2, and 3, my lord, these are the cousins of the informant, my lord. 4 and 5 are the sons of, my lord, accused number 3. So 1, 2, and 3 are cousins, and 4 and 5 are the sons of number 3. Now, your lordship will kindly come to. This was initially, my lord, registered under sections 1182, my lord, previous year. Subsequently, 109 was added to the case.
Attempt to murder.
Attempt to murder was added to the case. Now, your lordship will kindly come to page 24. This is a civil suit, my lord, judgment of a civil suit. This is filed by, your lordship will find the second plaintiff, Zohirul Islam. This is the victim, my lord, son of the father of the informant. And the others, my lord, are the petitioners before your lordship. So they have been feuding over a particular plot of land. This, initially, the plaintiffs in this case, my lord, the informant side, they got a decree in their favor. Thereafter, your lordship will come to page 37. We preferred an appeal. And there was a delay. So, along with the section 5 application, we preferred the appeal. By order dated 1/8/24, this delay was condoned. But thereafter, your lordship will kindly come to page 54. Against this order, my lord, whereby the delay was condoned, the informant side came to this honorable court by filing a CRP note, impugning that order. Then their CRP was dismissed by order dated 16/6/2025. Now, after this CRP was dismissed, my lord, then again the relations between them soured, things aggravated, and on the date of the incident, a fight took place because this informant side had also come. It's our case that the informant sides were the aggressors, my lord, but it is an admitted position, my lord, that an altercation took place. And it is also an admitted position that during that altercation, the informant's father had also sustained injuries. But it was a fight between both parties because of this land, market, because the market has taken place. So it is not in dispute that this father has sustained injuries, and the fight between them is also not disputed by us.
Let us get the CBN. Wednesday. Mankachar. Thursday.
Even if it's Friday,
Last day.
because Mankachar may take some time.
You offer the informant?
Yes.
At this stage, we'll silence you on that.
Yes.
I have a prayer, my lord, if my colleague is submitting some documents, let it come by way of an affidavit so that we can also respond to it.
You can do that. It's not a bad idea. I would say anything.
The injuries are not disputed, no. Injuries have been sustained.
There. For the background within the family, they are extended members of the members of the extended family. Anyway. All for the case that heard. Heard additional people or something. The 5 petitioners have sought prior respect. Connection with Mankachar case 116 of 25. All 4 case diary along with medical report. List on 26/9/2025 for CDN.
I'm deep.
Item number. Maybe this is right. Maybe.
Asking you for a time being.
But apprehending arrest warrant, we have filed this anticipatory bail application, madam. And what has happened, madam, in the meantime, madam, search sheet have been filed. And in search sheet, madam, we are not sent for, madam, the trial, madam. You'll also have this certified copy of this, madam, search sheet.
Where's the charge sheet? Page.
That is, we have, madam, recently received the copy. That is the last page, the names of the, madam, FIR, madam. And in fact, they are arrested and sent for the trial. Our name not appear, madam.
It's AB, right?
AB, madam. Last page, madam.
Then actually there is no apprehension. In a
Yes,
sense.
yes. Now it's not, madam.
It's not. So still wanted order.
Yes, yes. You also may observe, madam, that I'm not sent up for trial, madam.
So I need not give a protection. Protection order is not.
Protection is not required.
Not
in fact.
Yeah. If there is some subsequent development, then
Yes.
you can develop the rights. Anything? But I'm not disposing. They've submitted, but I'm not disposing those. But they can be given.
Or your lordship may,
Put a trial for.
for instruction, your lordship may fix it in the next week also. If your lordship,
Actually, only essential matters, it will be wise to fix.
Yes.
So, you may have some more.
yes, they are seeking instruction, madam. Let's go. No, I am not sent up for trial, madam.
And he's not, no, yeah, that is also true. He does not need any. Actually, in a sense, it is not maintainable. It's still-
Yes, now it's not maintained.
I'll observe and dispose.
Yes, yes.
That's.
That can be. The petitioner, Ali Hussain, had
Yes.
filed. Has filed this petition number 480 in connection with D4 PS case number 51. Heard to learned counsel, submitting a copy of the charge sheet submits, contains that, in the meantime, charge sheet has been submitted and the present petitioner has not been sent out for trial. What the learned action people or submits that necessary orders can be passed as per law.
Yes.
Look. Payroll. In view of the fact that the petitioner is not sent up for trial. The any apprehension of arrest with regard to the instant case would be baseless at this stage. And therefore, the anticipatory bail at the moment is not maintainable. It's accordingly disposed of. Needless to say that if there is any subsequent development adverse to the petition, you'd be at liberty to take recourse to appropriate options in law.
Your lordship may, my lord, mention the search sheet number, madam.
Oh.
That is called a serial 2, madam. First page, madam.
Yes.
Search sheet number 46
CS
of
46 of 20.
2025,
Dated
dated 18/8/2025. Deployable.
You take this back, or should it be
Yes, yes, your lordship may keep it on record.
record?
Yes.
Copy of the charge should be kept in record. If you pass short order, so to cover everything. Yeah, same.
In cases.
Similar ones. So you submitted that report regarding registration of any case and it's not yet been received. So what should I do? Because next week. Otherwise, the long time is given. So, right. Last day. 26.
They pleasure. Anticipating gain of. But the installment and the petitioner for the lawsuit, both are adults, no less. And they voluntarily entered into consensual relationships. Subsequently, the relationship broke up. And after the breakup of the relationship, the informant lodges his FIR. A lordship will find the FIR at page 9. May I read the FIR? Respected sir, with due respect, I would like to inform you that the below mentioned accused since the last 2 years has been in a love relationship with me. And with the pretext of marrying me, often
To him, when we got the information, we informed Sikona police station about the incident. My lord, this is the case of 326 and later on he succumbed to death, my lord. Charge-sheeted, my lord. My lord, lordship may kindly
Charge sheeted against all the 7 petitioners.
lordship.
Yeah,
prior to
tell-
that,
tell me.
My lord, kindly look into page number 17, my lord. There is another FIR, lordship. My lord, prior to that affair, my lord, petition number 1 lost this affair, my lord. My lord, may I read, my lord? Page 17, my lord.
This FIR against you, what is the date?
My lord,
Translated copy I'm not having.
first affair, that is, my lord,
No, lost by Sujata Das.
lost against us, my lord.
Yes.
And this is
That is
prior to,
ni-
my lord.
9/11.
My lord.
9/11, 14.
Yes, my lord.
14.
May I, lord? My lord.
This one is 2010. 9/11, 14. 2010, 14.
Clinton, my lord.
Yours is prior.
Prior, my lord. Okay.
Please read.
Most respectfully begs to state that on last 19/10/2014 at around 9:10 p.m., my lord, while my younger brothers, Sri Krishna Ran Das, the accused number 2 hearing, my lord. Petition number 2. Coming from Silchar after doing his work and on being entered the gate of land of Sri Rajendra Gorla, the accused persons who were hidden there with sword, lathi, etc., started assaulted my brother to kill him, and the accused number 1 holding a sword in his hand tried to slaughter the throat of my brother, but it hit to his left shoulder, was cut there. Well, basically, this is also under section 326, my lord. Previous argument.
But he survived.
But he's like so, my lord, basically what happens, my lord, after 10 years, my lord, charges have been filed, my lord, after 10 years. And our point is that, my lord, in the affair, my lord, page 21, my lord, we were shown absconder, my lord, in the charge sheet, my lord,
All 5 of them.
all 5, my lord. We are shown absconder. Now, at this stage, my lord, we are praying only for the prayer to protect us, my lord, to give us the chance to appear before the learned court, my lord. Learned trial court. Only our prayer is,
What
our
we can-
intention is that
What we can do at this stage is that, allow them to appear and get the TCR. Will that be okay? So, or not TCR actually. But it's just, case has just proceeded. CD and CS is given already. But still, from that side, CS and CD, will that be okay? I'm not saying we will support that, but that can be one course of action. Yes. So you can record your objection.
7/11 is the next date in trial for me.
7/11.
7/11.
Yours, sir, Mr. Soiti.
My lord.
Sure. Search for all. 482 application. Which are PS case number 9/11/14. Sorry. Which are PS case number 2759/2014. And so. Which was registered based on an Ezahar FIR dated 9/11/2014. 9/11/14. Arraying all the arraigning 7 accused persons, including the 6 petitioners here.
6 petitions.
All are named. The allegation is of assault, eventually leading to the death of the victim subsequently. Learned counsel points out that prior in point of time on 2010-14, the accused number 1 herein had lodged an Azahar against 3 persons. How are they related to the informant of this Sujata Das, Sukumar Das?
My lord, Sujata Das is the mother of the victim, my lord.
Mother of the victim.
My lord. She lost the affair, my lord, against us, my lord.
And Akhim Das, who are they? How are they related to the informant of the case against you? Case against you.
My
This
lord,
law has been lost by Sujata. This linkage, I just want to note it down.
my lord, we have-
Sujata Das is the informant in the case against you,
my lord,
and you're accused.
my lord.
He lost against 3 persons: Chandradhar Das, Adhir Das, and Sukumar Das. So are they related?
Odidas was
Oh,
the victim, my
Sukumar
lord.
Das. So lost against 3 persons, one of which is the husband of the informant of the present case, in which bail is being sought for. The said the allegations in the other cases also pertaining to assault and causing of previous injuries. It is submitted that after 10 years, charge sheet has been filed on 19/10/24 on date of the charge sheet. What is the date of the charge sheet? 24. 23. So to the printed copy. 19/10/24 FIR. Charge sheet. Date.
31 Lane Quincy, my lord. Last place.
Got it.
Hill Court place.
On 31/1/2024, in which the present petitioners have been sent up for trial, indicating them as absconders. The learned counsel prays that they may be given an opportunity to appear for the learned court hearings. In view of the despite the penal sections involved, so during the completion of investigation, after 10 years of the FIR, the prayer of the petitioner side can be allowed by way of an interim order, while calling for the scan TCF. Accordingly, call for the scan case diary and charge sheet of the learned court hearing. However, in the interim, in the event of arrest, 20,000 each, surety of the like among each. You'll be able to arrest surety on each, the satisfaction of the arresting authority to the condition, special appear for the learned court hearing, and otherwise cooperate with the process of law. At least the matter, learned, the learned additional PP seeking the scan TCR objects to grant of interim protection. Mistakes. We can fix it on the sometime. Yeah, after the vacation. 2014. 2014.
Deep level. May I please the lordship? Worship, the petitioner is the charge-sheeted abscond lordship. You should kindly see page 18 lordship. Page 18 lordship, here, this is FR lordship. May I read out lordship?
Yes, yes, I've gone through it, but you can read.
ইজাহারকারী জ্যোৎস্না বর্মন সয়েন্স এড্রেস লর্ডশিপ মহোদয় সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজী 20/2/2025 তাৰিখে ৰাতিপুৱা 4 বজাত মোৰ স্বামী বিৰাটনগৰ চাৰিআলিৰ পৰা খোজকাঢ়ি দক্ষিণ টক্ৰেশ্বৰ চতুৰ্থ খণ্ডত মোৰ ভতিজীৰ ঘৰত আহি থকা অৱস্থাত উত্তৰ ৰায়পুৰত এটা দুৰ্বৃত্তৰ দলে ষড়যন্ত্ৰমূলকভাৱে মোৰ স্বামীক আটক কৰি গছৰ লগত বান্ধি আসামীকৰণে মাৰপিট কৰি প্ৰাণে মৰাৰ উদ্দেশ্যেৰে গুৰুতৰভাৱে জখম কৰে। তাৰ পিছত গোলগঞ্জ আৰক্ষী পেট্ৰলিং পাৰ্টীয়ে গৈ তেওঁক উদ্ধাৰ কৰি গোলগঞ্জ BPHCত ভৰ্তি কৰে। অৱস্থা সংকটজনক দেখাত DMCHলৈ প্ৰেৰণ কৰে। যোৱা 20/2/2025 তাৰিখে DMCHৰ পৰা GMCHলৈ প্ৰেৰণ কৰে। এতিয়া মোৰ স্বামী GMCHৰ মৃত্যুৰ লগত জড়িত হৈ যুঁজি আছে। Accordingly, Lordship, on the basis of the contents, Lordship, one case was registered under sections, Lordship, 62(1), which deals in party of a criminal conspiracy, 117(4), punishment for
Attempt to murder, previous one.
Lordship. Lordship, 103 was subsequently added, Lordship. Therefore, Lordship, 109 is not applicable in this case, Lordship. Now, Lordship, the petitioner is not the FNM, Lordship. There are 6 persons mentioned in the FIR, Lordship, as accused persons: Soribuddin Sheikh, Aminul Sheikh, Soiful, Veda, Ainal, Sayuddin. So these are the FIR accused persons, but my name has not been mentioned in the FIR, Lordship. Lordship, now kindly see, Lordship, page 20, Annexure 2, Lordship, is the charge sheet, Lordship, charge sheet number 91, and it was submitted on 25/2025. And Lordship, kindly see at page 20, page, Lordship, Lordship, my name appears in the accused as accused number 11, Lordship. 11, Lordship, page number 29A, Lordship. My name appears, Abed Ali, who is the petitioner, Lordship, in this case, Lordship. And Lordship, now kindly see page
103, he died.
he died here subsequently, he died here, Lordship. Kindly see page 38, Lordship. So for page 30 is concerned, Lordship, here on the last paragraph, Lordship, during investigation, it was found that, Lordship, one Momin Rahman is the main accused person, Lordship, and he was taken, he was arrested and thereafter he was taken custody, Lordship. And Lordship, kindly see, Lordship, only page 20 of page 42, Lordship. Lordship, the entire charge sheet, Lordship, nowhere it is mentioned that how I was involved in this case, Lordship. Or simply there's a mention of the
That he is
name
involved.
of the petition.
He's involved. It is mentioned that he's involved, but not mentioned how he's involved.
Yes, Lordship. Lordship, kindly see, Lordship, Annexure 3, Lordship. Here, it is the order dated, order 13/6/2025, Lordship. Since the matter was charged, Lordship, a proceeding was started under PRC 457 of 2025. And here it is the order, Lordship, for issuing summons to the other accused person, Lordship. And Lordship, kindly see, Lordship, Annexure 4, Lordship. It is the summons, Lordship. And my name appears under serial 4, Lordship, Abed Ali Fakir, Lordship. Now, Lordship, kindly see, Lordship, Annexure 5, Lordship. Annexure 5 is the order, Lordship, passed by the Honorable Guwahati High Court for the co-accused, Lordship, Mintu Rahman, who is on the same footing, Lordship, and our Honorable High Court, Lordship, was pleased to grant him, Lordship, free arrest bail, Lordship. And thereafter, Lordship, he appeared before the learned trial court, Lordship. And he was on the same footing, Lordship, he was also absconded charged, Lordship. Now, Lordship, here, Lordship, since one section, Lordship, 103 is exclusive tribal by the Court of Sessions, Lordship, and Lordship, summons was issued by the committal court, Lordship. Therefore, Lordship, committal court, Lordship, at this stage, Lordship, does not have any power to grant me bail, Lordship. If I appear on the next day, that is 26/9/2025, Lordship, there is apprehension that, Lordship, I may be arrested, Lordship. Therefore, Lordship, the petitioner is before Lordship, Lordship. Kindly, Lordship, the petitioner may kindly be protected, Lordship, so that he can participate. He is ready to participate in the proceeding, Lordship, on any terms and conditions, Lordship.
Jagdish Parmar, victim.
Yes, Lordship. Jagdish Parmar.
Very serious injuries, very serious.
What about
Horrible.
Lordship?
Anyway, but there is two charge sheet is there.
Yes, Lordship.
Sufficient material evidence.
Sufficient material, only merely mentioned in their Lordship, sufficient materials, what materials are this not described, Lordship. Whatever it may be, the merit of the case, whatever it may be, Lordship, I am ready to cooperate in the proceeding, Lordship. I am ready to appear on the next date. That is 26/9/2025, Lordship. Since other accused, co-accused on the same footing, he was allowed lordship by by our honorable Guwahati High Court lordship. And I am also on the same footing lordship, therefore I may be allowed lordship.
Mr. Ahmed, A.K. Ahmed,
Lordship, A.K. Ahmed.
Learned Counsel, what are learned additional fee? Golabgon's PS case number 48/25 was registered based on a FIR dated 23/2025. Lost by the victim's wife, alleging severe assault on her husband. So it appears that subsequently the victim died. And the relevant penal provision was added. 6 persons are named in the FIR. So, though the present petitioner, Abed Ali, alias Abed Ali Fakir, was not named in the FIR, but after completion of investigation, he was sent up for trial as accused number 11, further indicating him as an abscond. It is submitted that the accused person denies his involvement and wishes to appear before the court. The charge sheet indicates severe injuries on the victim. Bail granted to accused number 8 of the charge sheet by coordinate bench. This court has been referred to by placing the order. And so is the absconder of this guy. Absconding.
Lordship,
The said person was also indicated as absconder in that charge sheet. The learned additional people strongly objects to the grant of bail. 6 dismissal at the outset. So, call for the scan case diary and scan case diary, including medical and PM report, as also the scan charge sheet. However, in the interim, this directed event of arrest. The following conditions are imposed. For one, they shall appear before the learned case. Number 2, he shall not abscond. Number 3, he shall not in any way, any manner cause any intimidation from a harassment or harm to the informant and her family. Stop. Number 4, he shall not hamper or temper. Shall not try to, he shall not try to intimidate or influence witnesses. In case of violation of bail conditions, the interim bail will be liable to be cancelled. Stop. Fixed on scan report, CD medical report, PM report, everything will be necessary, right? CD, CS, vote. Things will not only. When is the next date you said?
26 of this month, Lordship.
Yes, ma'am. This one is, sir, I'm giving you interim.
Next, Lordship. No, Lordship is next date is fixed.
Or 26. 24 10.
Much obliged.
May I please lordship? Estimated for execution manner. FIR is placed in manner. And the FIR has been lodged my lord in the family members manner, brother of the petition number 1 and 2 and aunt of the petition number
Uncle.
of
Uncle.
nephew manner. And lordship can place 10 manner.
19 years.
On suspicion, down by the FIR has been lodged.
Let us see the appearance.
Place 10 my lord. Married my lord.
See the
Okay.
Go ahead.
With due respect, I have the honor to state that I am living with my family at Guwahati for work. Since 17 days ago, my daughter is about 14 years, come to our house at number 3 Helamari. And on last 11/9/24, my sister accused number 2, that is the petition number 2, informed over phone that my daughter was missing from the house and above mentioned accused person physically assaulted my daughter since that day and on last till 9/2024. At about 5 a.m., the above mentioned accused number 2 informed on Swenso. At about 5 a.m., the accused Laili Begum informed my wife, namely Lakhi Kali, over the phone that her daughter was lying dead on the pond situated east side of my house at number 3 Halaman Village. It is come to note that the above mentioned accused the people and men killed my daughter. In this connection, my lord, the accused number 4, my lord, the mother of the informant member has been arrested by the police, my lord. Yesterday, I have also moved, my lord. And the same
Who is she? Sahara Begum.
Sahara, my lord, is the mother, my lord,
You
of
were
the
arrested.
object, my lord. All the family members, due to suspicion, after the lapse of 7 days, my lord, have stated in paragraph number 5, 6, and 7, my lord. And the informant asked for 10,000 rupees, my lord, for the religious ceremony for her this daughter, my lord, from her father, my lord. But his father is a rich Thalapula, my lord. He could not pay the same, my lord. That is why after 7 days, my lord, the FIR has been doctor.
Call for the case there, yes, at this stage. Serious allegation, conspiracy and peace. No, that is the allegation. 482. Kalmoa case case number 275 of 24. It was fire. Call for the case diary from the concerned police station. Please stop.
24, my lord, it is fixed, my lord. Along with bail application number 3056 of the
This
25.
on 24/9/2025, along with BA number
3056.
3. That's it.
Last.
Prosecuted case pending before the Signum Nagao Lordship. In this case, what happened on 31/7, the FIR is at page 12 Lordship. On 31/7, there was some quarrel wherein 2 of my employees purportedly assaulted the victim, Lordship, and he sustained previous injuries. And thereafter, they were arrested. The employees were arrested. And I was served with a notice under section 35(3) to 35(6) of the BNSS Lordship by the police. That is at page 18 Lordship. And accordingly, I appeared. And I cooperated in the investigation. Thereafter, on 21/1 Lordship, 21/1/2025, the charge sheet was laid, Lordship, by the police. And in the charge sheet, in the column of the details of the accused sent up for trial at page 21, it may be seen that the status of the accused issued to be under section 35(3) to 35(6), which actually there's typing mistake, Lordship. And the original is at page 25, Lordship. That is to some extent illegible. That is page 25, issued to be under section 35(3) to 35(6) of BNSS, earlier 41A of the CRPC. And thereafter, what happened, Lordship, my counsel made a petition before the trial court, actually seeking adjournment, and at that time, the civilian actually told that you cannot appear here because session tribal section 109 is there.
So he avoided.
Yes, sir. And thereafter, he filed a petition before the additional session judge, wherein also the learned was actually directed him to appear and actually order was to be passed as per. So there is an apprehension, Lordship. If I appear, I'll be definitely I'll be arrested. And the CCM has no power. The sections.
Page 37. Person died.
No, Lordship.
He didn't.
No, Lordship. Injuries, Lordship. There is a cut in the nose. In the FIR is
307 must be there. 307.
Yes, Lordship. 109 of the BNS and 1182 Lordship. These two sections. So on 22/9, the case is fixed, Lordship, for appearance, and NBW has been issued.
The page 37.
Yes, Lordship. Page 37, 6/8/2025 dated order, fixed on 22/9/2025. And by this order, actually NBW has been actually issued.
Initially, someone. Cognizance was taken.
Yes, cognizance is taken, Lordship.
No? Oh, 37.
But page 37, madam. Kelgora was given last sum's.
Ah, yeah.
And this is the actually difficulty, Lordship, if I appear. And I have not been shown absconder, Lordship. I actually have cooperated the investigation during the period. There is evidence.
So he has not put out the
No, I
And
mentioned that. Anyway, you appear
yes, first 122/9. I shall appear.
482. NSS. Yes. Nogao Sodor PS case number 753 of 24. So
PSC number is also there. Lordship.
the present petitioner, one of the name, was one of the name accused in the, as I heard, FIR dated 31/7/2024. The allegations in a very nutshell pertain to assault the victim by some persons. And and the present petitioner is also alleged to be involved in instigating that assault. After completion of investigation, charge sheet was stated to have been submitted. Table the annexed documents in this regard. Due to the non-appearance of the present petitioner before the court, learned court hearing, NBW was issued fixing the next date on 22/9/2025. It's true. They submitted that due to the penal provisions of the charge sheet, the petitioner, the accused petitioner apprehending arrest. Upon apprehending, being remanded to custody upon the appearance, and therefore has come before this court. Lord learned additional people who seeks the scan TCR while opposing the prayer for interim protection made by the learned petitioner counsel. Call for the scan. We'll call for the scan to be, yes, call for the scan case diary and charge sheet along with medical report. However, in the interim, arrest is directed to 20,000 to 25,000. Subject to the conditions that will appear before the learned court will as directed, semicolon, not hamper or tamper with evidence, and shall not cause any harm or intimidation or harassment to the informant and his family. Please instruct. That is the only concern in this.
Obliged.
She's from 2410.
Deeply obliged.
देखिए actually please.
Yes, your lordship. Lordship will pass over the matter.
After some-
time after simple. Seniors are like senior.
You can also do if you want. Would you? Right?
Lordship, I'll wait for my seniors.
You can do it. If you get stuck, you can wait later. Okay.
But please. In this case, should be FIR is bona fide. But the police is searching me on for interrogation that because I have very clearly mentioned in the petition in this case.
Report is not there. Pirus, last order dated 16/9/20. The report as called for is not yet received. And prosecution 6 another date. When should I fix it? 23/9 for reporting.
In the meantime, Lordship, otherwise, Lordship, sir,
There's no data.
not to harass Lordship on
Treat-
these slides. Otherwise,
That is,
because Lordship and page number 4, Lordship, I'm very clearly mentioned number 2 phone number, Lordship, and the one EMI number of the mobile Lordship has been sent to my mobile Lordship, by SMS. And I am the businessman Lordship and the Geotech Mobile Repairing Center. There are numbers of people who visit my shop repairing their mobile, and if someone is Lordship. So on that basis, Lordship.
this one, in the meantime, I can just give this kind of an observation. In the meantime, the petitioner as a petitioner stated to be a law-abiding citizen, shall cooperate with the process of law. And he shall not subjected to any unlawful harassment.
Lordship, so published.
That's all. To or 23rd.
Published.
Will also be very busy today.
Wait, please, your lordship. Lordship, this is also a similar type of case, lordship. Yesterday at 2, lordship has called, lordship, to a yesterday, lordship, I feel. And
You are not.
best well leave the court, lordship.
You're better. Feeling
Today is today,
you have a weekend take this.
lordship, what happened, since they said, lordship, no case registered, but yesterday, lordship, at 4:15 and 7 PM, lordship, one SI, lordship, P. Pegu, lordship, went to the house of this petitioner, had humiliated the parents of this petitioner, lordship, along with his grandparents, lordship, even a threat to encounter this petitioner, lordship.
He has the dignity, he can file appropriate application. before-
But, lordship, if no case is there, lordship, that's why I'm saying, lordship.
Spec is also there.
Yes, lordship, today morning, lordship, he came to my house, lordship, said, lordship, these things has happened, lordship. If no case is there, lordship, why they are appearing in the house of this petitioner without a warrant, lordship? They have no such warrant, lordship. They entered the premises of this petitioner, lordship, harassing the parents of this petitioner, lordship.
I'll
Some
dispose of
protection, lordship.
Actually, there's no case, specific order. of
Because, lordship,
anticipatory bail
then why,
cannot be given.
then, lordship, why harassing this
That I
petitioner?
make an option.
Yes,
Like the previous one.
that's why I'm specifically named the particular, lordship, police personnel, lordship, SP P. Pegu, lordship. He threatened this petitioner parents, lordship, even encountered this boy, lordship.
Personal job also, he can move.
Personal girls, lordship, what will be the personal girls, lordship? It's a young boy and girl, lordship, fall in love. They were sent back, lordship, lordship, the parents have sent back the girl to her house, lordship. It is admitted fact, lordship. When she came back again, lordship, she was sent back, lordship. If she did not return to her home, lordship, what this petitioner will do and their parents will do, lordship?
So, okay.
For that, you cannot harass a person, lordship.
Police bad behavior.
Yes,
is
lordship.
is a reality of in some cases. So many citizens face this problem. In fact, that is one area they have to work on if they want, if the police wants a citizen friendly. People to like police more. So in this kind of situation, one road is to approach higher police. The police as an institution is positive. You cannot say that. So you can approach higher, I'll make my observation. You can approach
Yes.
higher police authority or the quasi judicial mechanism which is there. It's fine, right? Yes. Pirus order dated 18/9/25. Report was called for. Report was called for regarding registration of any case against the petitioner in Tezpur police station. It's to pursuant thereof, learned additional PP has submitted a report stating that no case has been registered with the petitioner in the Tezpur police station. In view of the same, there is no legal basis for any apprehension of arrest. However, the learned counsel submits that the From Tezpur Police Station, harassment from Tezpur. Police
Yes, from Borghat Outpost, Lordship, the personal Lordship,
This
police
is-
personnel
this
from
is-
Borghat Police Station, Mr. Pegu, Lordship.
Station. It is
SIP Pegu.
it is submitted that SIP Pegu from Borghat Police Outpost under Tezpur Police Station has been harassing the petition. The the police is at liberty to proceed as per law in case of any allegations of, in case of any allegations of criminal act on the part of the petitioner, however, it is as stated above. A written report has been submitted by the police from the police station, said police station, that no case is pending against him at the moment. The petitioner shall not be subjected to any undue harassment. This AB stands disposed of for sections. Highly acknowledged. This can be kept here.
Yes.
Same, so, yes, same. All of these cases are coming. So. Pre-arrest based. Yes. Prevention or registration of case actually. That is the. So, we have some report? Yes. Okay, this first time. The petitioner is apprehended, has filed this petition apprehending arrest, but does not have details of any FIR or police case against him. Call for a report from the council police station. As to whether any FIR registered, FIR was filed or any case registered. In the meantime, the petitioner should not be subject, may not be subjected to any unlawful or undue harassment by any law enforcement authority. Based on when based on the protocol for report. These are the only dates. We have. What happened to that? Because of judgment that all FIRs have to be uploaded. They're not, they're uploaded. So from there, actually, one can also check oneself. You can also, any citizen can also check whether any FIR details have been, but some things will not be uploaded, like so. But that was a very good direction, I think. So just try it. I'm giving a similar order, but you just try in Patsala police station. Each police station does not have a website. Do they have website? You need to be selected by someone in cooperative police. No, here it is Patsala. The petition that I'm taking. In the other case, it was cooperative. That case it was cooperative. Patsala case. Same order. You tried it on an experimental basis. You tried Patsala base case, or if it is where stations had not have individual websites, SP Patsala, SP Bozali. Getting the name, they were the great judgment. Direct requires to be uploaded. Yes.
May I please your lordship? Lordship, similar case, when I filed the bail application, my lord, there was no FI registered. But subsequently, my lord, FI was registered on 25/8, and lordship, what the last order dated 5/9, lordship. I was asked to directed to bring the FIR on record. So my lord, I filed my additional affidavit and I brought the FIR on record. My lord will find the FIR on page 30. Page 30, my lord. Lower left corner.
Allegation of some financial
My lord.
misdealings.
Civil dispute, my
No,
lord.
no, not, let's see. Financial may not automatically make civil. Yes, as you know, let us read.
My lord, if it's okay, my colleague will read the FIR and not very good in reading the language.
No problem, you can read English.
My lord, the translated version will not perhaps because the FIR itself is basis and vague. So there is no, my lord, my.
It's given for our convenience, but it is always better to read the original.
My lord.
So there is this thing called lost in translation.
Page 38,
This,
38. বর্ণাগুলো
writing is good.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে মোৰ কোটিকটীয়া RD মটৰ্ছ ওচৰতে গেলামালৰ দোকানখনত যোৱা ইংৰাজী মাৰ্চ 2024 চনত বয় বস্তু কিনা সময়ত দ্বিতীয় পক্ষই নিজকে লোনৰ কাম কৰা বুলি পৰিচয় দিছিল। পিছত ময়ো লোনৰ কাম বুলি কোৱাত দ্বিতীয় পক্ষই মোক ইউকো বেংকত 25 লাখ টকা লোন দিব বুলি কৈ মোৰ পৰা মেনেজাৰ বেংক ফিক্স মিলাই 3 লাখ টকা লৈছিল যদিও লোনটো নহল। পিছত SBI হৈবৰগাঁও ব্ৰাঞ্চত দ্বিতীয় পক্ষই পুনৰ লোন দিব বুলি কৈ 2 লাখ টকা লৈ 20 লাখৰ লোন এটা উলিয়াই দিছিল। ইয়াৰ পিছতে দ্বিতীয় পক্ষই ৱাইন শ্বপৰ লাইচেন্স খুলি দিম বুলি কৈ মোৰ পৰা 17 লাখ টকা নিছিল যদিও লাইচেন্স নহল। বৰ্তমান দ্বিতীয় পক্ষই লাইচেন্স নোহোৱাকৈও ৰিনিউজ পাৰিম বুলি 2 লাখ টকা আৰু মোৰ নামত 4-চকীয়া গাড়ী কিনিম বুলি কৈ 3 লাখ লৈছিল। দ্বিতীয় পক্ষই উক্ত লোনখিনি মোক লক্ষ্মীনগৰত হাৰ্ডৱেৰৰ দোকান খুলি দিম বুলি কৈ লোনৰ টকা শেষ কৰাত বেংক কৰ্তৃপক্ষই চাব বিচৰাত মই মাটি বিক্ৰী কৰি পুনৰ 14 লাখ টকা দ্বিতীয় পক্ষক দিছিলোঁ। দ্বিতীয় পক্ষই দোকানখন মোৰ পৰা হস্তান্তৰ কৰি দ্বিতীয় পক্ষই EMI দিব বুলি কৈছিল যদিও EMI বিচাৰি মোক বেংকে নোটিছ দিয়াত যোৱাকালি আবেলি 5মান বজাত দ্বিতীয় পক্ষৰ আমোলাপাট্টিত থকা হাৰ্ডৱেৰৰ সৃজন ছাপ্লায়াৰ্ছ যোৱাত দ্বিতীয় পক্ষই মোবাইল ফোন লৈ ওলাই গৈ নিৰুদ্দেশ হয়। এতেকে উক্ত আসামীজনে মোৰ লগত আজি বহুদিনৰ পৰা মোক সৰল বিশ্বাস জন্মাই মোৰ লগত সব প্ৰবঞ্চনা কৰি আহি মোৰ লগতে মোক পৰিয়ালটোকো বিপদত পেলাইছে।
So my lord, the allegations are vague, baseless, not at all connected. In fact, my lord, what has happened is that in this matter is that my lord, me and the informant were in a series of business transactions. Over one failed business transaction, my lord, they had come and attacked me on 25/7. I had lost the complaint. That complaint was never registered. That lordship will find that in my bail application, page 14.
Prima facie, the elements of cheating.
Yes, my lord.
And he was also foolish. So,
From 2024, my lord.
and giving money again and again. He said, "Police don't feel good." Apparently,
My lord, the face of record, unbelievable story, my lord.
it cannot be said. At this stage, I would like to see the case there. What is where is your complaint? It's like
On my lord, page 14.
page?
Page 14, my lord. My lord, this I had lost on 25 July 2025. May I read the, my lordship? No. No.
This was not registered.
These were not registered, my lord. And subsequently, this FIR was filed on 2nd. And then, my lord, it was registered on 20 5/8 after the interim protection was granted to me on 22nd/8 by the Honorable Court. My lords, may kindly have the order dated 22/8. My lord, the second last paragraph. Further submitted by Mr. Mittal and counsel submitted that the police personnel harassing the petitioner till date over telephone and hence some interim protection may be provided to the petitioner. Considering the submission made by land counsel is directed that no coercive action shall be taken against the petitioner till the report is released from the concerned police. My lord, subsequent to this order, the FIR was registered.
Let us get the, here's the,
Till then, my lord, this protection might continue, my lord.
it's not, the judicial conscience is not permitting me. Let the investigation proceed a bit.
My lord, at least, my lord, till the CD is there, my lord, I may
No,
be.
no. Some, or some cases,
My lord, by car
cases, it
my lord,
cannot be, there's a lot of
my lord, the police are
Elements
perhaps
of
acting on
cheating.
the behest of the informant.
Anyway.
Going to reasons best known to them.
call for the case diary of Nogo PS case number 682 of 25. That's when so. First of, here is the FIR. Call for the case diary. You can. Short. Before the case.
My lord, till then, my lord,
No, we'll
at
take
least,
it.
my lord, no coercive action.
I just want to, no, that's the same.
My lord, at least, can we continue the course here?
No, the same thing. It's the same. That's the same. 25. 25, whatever.
Yes, my lord, I'm already on coercive action, my lord, there is already a rejection.
Vacating them. Whatever it is, it was in the context of no registration of case. In the meantime, it has been used.
May it please the lordship. So that this is a pre-arrest bail application. Well, in this case, your lordship will kindly look into the FIR at page 18. Page 18 is the FIR. Then your lordship will find that the FIR has been registered for criminal breach of trust, cheating and dishonest misappropriation of property and common intention. Now, as for the FIR, my lord, at page 3, your lordship will find that there some gold was kept there in the locker and arrested accused was seen in the CCTV from taking out the gold from the locker and misappropriated along with another lady. So far, I'm concerned, I'm the branch head of that office, and against me, more or less, it is the supervisory absence. Your lordship will find there, so far the allegation against the arrested accused is concerned. Prima facie, your lordship will find at page 28. Page 28, your lordship. Your lordship will see that just below that table, the paragraph.
Your good name is?
Moon Ahmed.
Moon.
You'll also see just below the table order.
Yeah.
Further, an
An
examination
examination.
of the CCTV footage of Asirvad Microfinance Security Branch dated 35/2000. Accused Kuldeep Deka was checking out 2 gold packets. This is why the FIR is concerned. From the ballroom and concealing in his pocket of the pen worn by accused Kuldeep Deka, as such, prima facie, the involvement of accused are found. Then your lordship will look. Then your lordship will find at page 43.
Moon Ahmed. Mention this prime accused.
Yes, ma'am. Because I was the branch head. But your lordship, that was at the preliminary stage of investigation. Later on during investigation, it was found that Kuldeep has arrested. And Kuldeep has been granted bail by this honorable court. Of course, after his arrest, that is at page 43. And your lordship will find the another accused also who was part of that conspiracy was Ria Paul. That is at page 46. He has also been arrested and granted bail.
The bail order of Kuldeep is at page 43, Ria Paul is at page 46.
See,
So today only I'm praying, my lord, till your lordship looks into the case diary. Interim, your lordship will grant me, I'll go and appear before the police and record my statement. Then after that, your lordship will decide it finally on whether I'm entitled to bail or not. Because prima facie, I have been able to show to your lordship that the accused person who had taken out the from the locker and it was seen on the CCTV camera.
details of employees suspected in missing. He's
Yes,
been
sir.
missing from the.
Because when there is a non-bailable offense arrest statement, we always take a, first we go and have the bail order, then only we go and appear before the investigating agency. Otherwise, this is not a case where in the charge sheet I have been shown as an absconder because preliminary stage, my lord, the FIR was registered. After investigation, they found from the CCTV footage that this person, Kuldeep Deka, was the person who did it.
But on its senior counsel.
I would like to point out one incident. When I came earlier to a good person, say, they are following and will be present. They are following initially they are very position, and there are some only on the ground for you can say 8 hours last. So here bail eviction order is also available. Here, my tell misappropriation of the amount is more than 74 weeks. Is a big kind of self-containment. Regarding the involvement of the present accused person, he is the mastermind. He, along with other accused persons, I will point out to your lordship from the forwarding report, because these are the rejection of the rejection. Regarding the present accused at the time of rejecting the bail petition, here I would like to point out your lordship may kindly come to page 27, that is forwarding report. Regarding the summary of investigative details.
Paragraph.
Page 27 of the present petition. Summary of investigation details.
I've seen it.
Yes. Regarding may I read my
Page 27.
page
So
27?
I've seen it. You can point out.
Yes, that is specifically mentioned about regarding the assets and thereafter what they have done, tell 19 numbers of gold packets. They were chains which may not out of these 19 packets, 7 packets were found to be missing, whereas 12 packets of gold were found to be replaced
Fake.
with fake
Alice, allegedly fake.
Yes, and they are the present petitioner along with Kuldeep Deka is the custodian of the whole area. The present petitioner is by law directly associated with Paul is not the employee of the present finance company. She is from a different company. The Moon Ahmed is by law real acquaintance who is perpetrated with the Paul. Thereafter, how he along with Paul, because earlier I have come through the case diary. Earlier I appeared regarding 28, page 28, I would like to point out one from the forwarding report itself. Paragraph 3, as revealed by the witnesses, the prime accused is in the present petition. In connivance with co-accused Kuldeep Deka had brought out some gold packets and later they were either sold or deposited in other gold loan companies in the name of unknown customers. So other gold loan company is the she is Ria Polman. Thereby they collected thereafter by depositing those goals, they in fact provided loans to some other persons. So how they all are involved in this
Thereby they collected fares and same were shared among them. Requisitions have been sent to SFL, gold loan, equity bonds, and etc. So many these are the allegations, and now he is absconding. All the other two accused persons were arrested and thereafter only initially rejected, thereafter only gone of left for detention, they were allowed to go and do. His custodial, the present accused persons custodial, recovery of some other gold items is yet to be recovered. And how these accused persons is involved in the persons to whom he has provided those loans, along with information which they have needs to reveal them. So he's considering them as if
Yes.
offense.
I'll just reply. Do have one short reply. Short. My lord, yeah, scissor list I have not annexed, but I have a copy of the scissor list. Some of the goals have been recovered from the residents of the Riapol and the other. Those scissor lists are there. So it is, my lord, today I am not seeking that your lordship will grant me permanent bail. Only to, the allegation is that I am not cooperating with the investigation. Your lordship will fix it. Date. I'll go and appear before the IO within that particular date. After that, my lord, if your lordship finds that there are materials which will justify my custodial detention, then your lordship will direct accordingly, and we are ready to follow the due course of law. But today I am only, the main allegation is that I am not cooperating with the investigation. These are the scissor lists from them. That's why they were kept in custody. My lord. Your lordship will also look.
Anything else?
No, ma'am. Sorry. Obliged.
Or Julie PS case number 163 of 25 on sections also. So there's a FIR dated 11/6/2025 was lodged for Julie PS by regional head of audit from Ashirvad Microfinance. The allegations, the gist is about misappropriation of gold deposited by customers. The two accused persons are named, including the present petition, who was apparently the branch head where the alleged offense took place. Learned senior counsel submits that the petitioner at this stage seeks interim protection to go and appear before the investigating officer. This is also pointed out from the copies annexed that two co-accused, including one named accused, were granted regular bail by this court. On the other hand, Mr. Borthak, additional cases vehemently opposes the prayer for bail, pointing out the implications against the present petitioner, and also stating that the bail granted to the other two persons was largely on length of detention and stand on a different footing. I peruse the detailed FIR. The present petition stated to be the prime accused and also stated to be missing since the date of the alleged incident. One of the statements in the FIR is that there was replacement of original placed gold with fake items, suggests pre-planned misconduct intended to cause financial loss to the company and its customers. In the given situation, it may not be prudent to allow the prayer for interim protection, and the same stands rejected. However, all for the case diary of Julie PS case number 163 of 2025. Fixed on when you suggest the date, since we are not giving interim 25.
Obliged. I'll make a committed to take back the scissor list.
Yeah, that is, you'll need it also.
In this case, FIR lordship will find at page 9. Victim is the daughter-in-law of the present petitioner's lordship, and after death of the lady lordship, the father lost the case. And thereafter, this parents lordship, they were arrested along with the husband. Husband is not before your lordship.
Husband and
Husband is not before your lordship. These are lordship, in-laws of that deceased.
parents in law.
Parents. Their lordship, here lordship, allegation is that the accused number one, that is the husband, used to
Or can copy means it's a charge sheet.
Certificate case lordship earlier two times lordship the call for the skin. Still that not so.
The scanned TCR as called for has not been received. We'll need the case diary also.
Along with the case.
Actually, more than the case record, we'll need the case diary in the charge sheet. That's case record will be about the orders, appearance and all these things. Main thing is the investigation. Investigation and what is finding in the charge sheet. Sometimes only charge sheet will also be sufficient. These days. He's in custody since.
2 days, 101 days.
10/6/25.
The scanned case record as called for is not yet received. Prosecution seeks another day, which is allowed. The scan copy of the case diary.
Case diary.
Case diary and charge sheet may be procured. Case copies of case diary and charge sheet may be procured from the court below. Considering his length of detention, we cannot give after vacation also.
Before vacation.
Will it come? We fix a date.
So like.
26.
26. Take a chance. 26/9.
Next.
Yes, ma'am.
Case diary of public communication is. The final postmortem report is still awaited. That's the case diary.
The case diary has come. No.
Short date, my lord, will be on 24.
Still 7. Death case, is it a death case? Dead body was. Thank you. Case diary. Case diary and PM report is called for not yet received. Issue reminder. Accused is stated to be in custody since 16/7/2025. This on same 26. No,
The last date was 25.
25, say for 25/9.
May I please, your lordship? Your lordship? Your lordship, this is the second time. Moreover, your lordship, I am behind the bar for 80 days. 90 days is the, your lordship, mandatory periods. And please go through the, please, your lordships, peruse the FIR. Case 15, your lordship. 80 days I am behind the bar, your lordship. It is the second day, third day, your lordship, the city has not been sent, your lordship. I hear your lordships, the allegation is attempt to life your lordships, but nothing happened, your lordship, no injury, nothing, your lordship, on perusal of the FIR. You see, I'm already behind the bar for 80 days, your lordships, without doing anything, your lordship.
Your name is?
Your lordships?
Farhad. Farhad Ali,
Your lordship, Farhad Ali.
sole accused.
Your lordship.
Anyway, diary has come. Diary not come. Diary not come.
I am already behind by 80 days, your lordships.
It's okay.
Your lordship, on mere perusal of the FIR, your lordships. Nothing that any physical assault or anything happened, your lordships. Only on the basis of apprehension, your lordships. And only on the basis of apprehension whether I can be put behind the bar for so many days, your lordship. I am already on 80 days.
No, he's the sole FIR name. Okay? And his delegation is that attempted to kill him with a short iron spike.
Your lordships. But your lordship, the allegation is that the attempt. Nothing is there, your lordships.
And the accused person killed.
Moreover,
complainants.
your lordship, one thing may be considered. This FIR was lodged after 6 days of the incident, your lordship.
So there is allegation of causing death of one and serious injuries, attempting to cause injuries.
Date is regarding other, your lordships. Not about this informant, your lordships. And in that case, your lordship, I have already got the bill. In the date case, your lordship.
Get the which police station? Yes, sir.
Your lordship, 80 days.
I'll consider case diary is called for not yet received. Without diary, it's kind of matter. So fixed on 24/9. If it doesn't come on 24/9, prosecution, we are under a lot of pressure. So kindly try from them because of the vacation.
May please, your lordship. Lordship, here the petitioner was arrested on 24/7/2025. As on date, lordship, he has completed 58 days. FIR, lordship, is at page number 14. They kindly come to the forwarding. In the FIR, lordship, nobody is named. As because lordship, that was a case of dacoity, lordship. Page number 20. And my lord may kindly come to page number 21. Grounds of arrest. The below noted accused persons found their involvement into the case. The victim and family members has identified the arrested accused persons. Next page, my lord. Sufficient evidences have been found against the accused persons. Lordship may kindly come to clause number 5. The looted jewelry items were recovered from the arrested jewelry owner shop, which was sales. It should be sold.
Yes, written wrongly actually. So which was sold by the.
Sold by the lordship. This is not translated. This is lordship typed. It
No,
was written.
I know here.
Yes.
I was written wrong.
Yes, my lord. Was sold by the arrested accused person's mother, namely so and so, of so and so, and the owner of the jewelry shop is ANI Shankar. Now, my lord may kindly come to clause number 7. The looted jewelry items was sold by the arrested accused mother, namely so and so, of so and so, to Shibu Das Nath and Ayan Das. My lord, this is the petitioner Ayan Das. The petitioner is the owner of the jewelry shop.
By the arrested. And Ayan Das.
Ayan Das.
This is the petitioner.
He is the petitioner, my lord. And lordship,
He was arrested on.
he was arrested on 24/7, my lord. And thereafter, my lord, 3 days police remand was given and he was there. And
My lord, may kindly come to page number 25, the second forwarding report after completion of 3 days police custody.
25. Page 25.
Page 28, my lord. Relevant would be page 28C. Annexure 3. Now, grounds of arrest, number 4. The looted jewelry items were recovered
Yes.
from the, my lord. And my lord, may kindly come to the next page. Only two close number 7 and 9. The looted jewelry items sales by the arrested accused mother,
Same.
and 9 is the new, my lord. Shibu Kumar Nath, owner of jewelry purchased the looted jewelry items from the arrested accused mother, and he also sells the looted jewelry item to Anil Jankar. He is also the owner of so and so. Now, my case is that, my lord, the petitioner
He purchased.
Yes.
Stolen property.
Yes. And already 58 days, my lord. We have learned a lesson or two, and allow me to go on bail with any condition.
CDS company. Voluminous. Huh?
It's an admitted fact that the petitioner was received, these orders may receive a stolen property, which has been taken by the decorative.
Decorative.
Yes. So in the earlier occasion also, so there is another case, which is item number 29. So
Another case.
After the arrest in this case,
some days are not. Because he knowingly, when it's knowingly received, he's not still received just for the received by way of decorative action.
The statutory period is 60 days in this case, 90 days.
90 days.
Well, it is 411. The previous 411. There's so many sections, that subsections that.
3.7, subsection 3, yes.
yes.
Josh, this, Bazairera PS case number 77, right?
Yes.
331(8).
3.7, subsection 3 of the MS. 3.7.
It's not telling. The case number is 77. 77.
Section 317, subsection 3.
3-1 says.
Yes. Subsection 3.
Oh, yes, I remember. It's the aggravated form of receiving stolen property.
Yes.
The imprisonment for serious offense. Should I see the case diary?
Yes.
But I don't have much time to see it. Just today's special. But, heard. The council and I said for a learned additional people. 483 bail application, seeking regular bail for accused Ayan Das, stated to be in custody since 24/7/2025 in connection with Bajari Cheda PS case number 77 of 25. The allegation in the Azahar dated 26/5/25 is about dacoity in the house of the informant and looting of valuables. The learned counsel submits that the accused is in custody for 58 days. The main materials, as per the forwarding report at the time of his arrest, the main implicating materials stated against the present accused is that he purchased the looted jewelry items from the mother of the accused, was also arrested, and in turn sold that same jewelry to another person. The case diary has called for receipt. Learned edition of AP submits that the present accused was shown arrested in another criminal case of similar nature. Possible to go through and get. Statement of that co-accused is there, mother, there.
Yes, yes.
Co-accused statement is always, co-accused statement is also always has to be seen critically, but still.
That is the mother of the co-accused man, arrested person and his mother. I think she was not arrested,
Statement of the mother.
mother of the arrested person.
She the accused also.
Sees
No.
that stolen property has been given to the mother of the accused, then the mother.
She is not an accused. No,
She's
man.
not an accused.
Not an accused. What a servant. Silence.
She is sold out the-
Ah, she's accused mother, who's also an accused. But- Jury during the court.
Yes.
The medical report, on medical report of Soylent Paul is available report. Is there, it indicates injuries or physical, allegedly upon physical assault. A sharp weapon leading to previous injuries. These allegations differ.
One of the same mentioned somewhere.
The learned additional PP points out that it's not just a case of receiving, knowingly receiving stolen property, but receiving such property, which is the subject, but receiving such property, it's a subject of dacoity. Considering the implications and the non-completion of investigation, the bail petition stands rejected at this case. For the time. There are public safety issues, actually, very serious.
Respective item number 29 also.
Same,
Same.
who was this person?
Your lordship, the petitioner was shown is arrested.
Oyan Das. This was also Oyan Das.
This is
Shown arrested.
Yes.
shown arrested
This
on
serious
11/8.
defect.
Same. Cities different. Same sort of allegations.
Same sort of allegations.
Yes. Then it goes to the statement of the petition.
He was arrested on a different day. Probably.
Yes.
Your lordship on 11/8.
This is bail petition, item 29, right?
29.
2832.
Ramakristan number 56.
He was arrested, shown arrested in this case on. What is the date? This
Why not 11/8?
11/8. Which statement do you want me to see?
That was the statement of the petition.
Petition.
Yes, I understand. Yes,
Self-incriminating. As per the medical report, with regard to one Rahul Paul, shows multiple injuries caused by a blunt weapon. However, the injuries have been categorized as simple. Is submitted by learned additional PP that. This investigation has also revealed incriminating materials against the present accused,
so it's a recipient of this.
and that he is prima facie a recipient of property stolen through dacoity. Let them, for the moment, let this. It's not be correct to give bail here at this stage also. This also. Let the investigation proceed. I want to understand.
Civil sandbag.
Highly
We
approved.
return the case then.
It applies.
I'm appearing in item number 30. It's along with 31 and 32.
Okay, you are appearing from?
Item number 30. This speaks for the case diary along with the medical report. Item 30.
Gautam Law Court. Gautam Law Court.
Yes. And my apprehension is at paragraph 7 and 8. So, sorry, not apprehension, my
Regular bail.
grounds, paragraph 7 and 8. I'm in custody since 9/8/2025. Last 40 days in custody. Other custodial detention may not be
40 days. Can you submit that again? Which page? Which page of para?
But date of arrest I have mentioned in the cross title itself. And
Yeah.
then paragraph 7 and 8.
Para 7.
Is that those coconut seller just in front of those Cotton College and all those small vendors?
Oh,
They sell coconuts to the
what
morning.
is, since the FIR is common, same case, right? So be worthwhile to see it thoroughly.
FI you'll also will find, so it starts from page 19. And the main is at page 22.
22. I'll read it.
Now, because in front of that earlier Cosmo hostel, that Khawguli is there. All local persons,
9 persons were mentioned.
yes, nobody is going to abscond, madam. They cooperated with the investigation, appeared at the police station.
He was suspected of theft and then allegedly assaulted. One died. One died.
Public beating, probably, madam. And even those people who are have their shops in that Khawguli, they also belong to the lower economic strata of the society. If somebody suspect, madam, then 1, 2, and if it's a vital part of the body, then that. I'm not on those technicalities now, madam. Since I'm in custody for last 40 days, 41 to be precise. Further custodial detention at this stage may not be required so far the investigation of the case is concerned. We are ready to face the trial and we'll.
All way, 6 people were forwarded.
Yes.
All the bail applications, these are
Yes.
all the arrested.
All
on the same day.
there are someone they were, my lord.
Soon the order to whatever it is. So this person is Virajul. No, the bottom locker is not in this
Gautam-
forwarding. Oh, yeah. Yeah, he's
According is the
he's also. Okay, now you tell me.
page 33.
I got. They have been custodially examined also.
Yes, statements of the witnesses.
No, they were in police custody for you, and are you in a position to say how many days?
No police custody
No
was
police
taken.
custody. No police custody.
From the present petitioner, my lord, there was no police custody here. For
Yes.
some, it was required, my lord, that your lordship will find at page 32.
So they was some
Yeah.
sustained during the night, but all the injuries were.
Homicide.
So
You just have to decide, I mean, think now that whether, what are the materials, progress of investigation, whether they are necessary.
the statement, the victim as well as the statement. This is. So the present witness has been discussed.
The materials. Yes. Yeah,
With respect to item number 30.
Each may be different.
Statements.
Each may be different.
And even if your lordship looks at,
No, I think just keep it with you, but the others are there, might need your assistance.
Yes.
Others are there.
Yes.
and that's why probably, my lord, at page 32, your lordship will find that my police custody was also not sought for.
The statements I have found.
Yeah. He's been in custody, so he should be released on
We are obliged, my lord, because
Nowadays, right, as you know, BNSS, rightly or wrong, 90 days offense, up to 60 days police custody can be taken. Not 60 days. police
no,
custody.
means
15
within the
days.
60 days.
Within 60 days.
It may be together, it may be in part.
60 days statutory period, up to 40 days. So sometimes I've seen prosecution that reducing that as one of the ground. Now, it's not taken, but it may be taken in the future. May be necessary. Very well, not applicable. It's like relevant games. Senior counsel, PD. System, right?
SJ. Sanjukta ji.
It's possible. The instant bail application filed under 483 BNSS, seeking regular bail for Gautam Law, who is stated to be in pre-trial detention pursuant to his arrest on 9/8/2025 in connection with Anbazar PS case number 259 of 2000 under section 1. The case arose out of an FIR dated 8/8/2025 lodged lost by a police official with the allegation about finding an injured person who was taken to hospital but died. It is alleged that another injured person was found in the area, and he was also hospitalized. It is alleged that in the early hours, these victims were assaulted by some shopkeepers of the area, who suspected them of theft. 9 persons have been named as accused suspects, including the present petitioner. Learned senior counsel submits that he was not custodially examined, as police did not seek the same. Moreover, he has spent 40 days in custody. 6 bail, at least is learned additional people. Submits on the basis of the received case diary that after that investigation so far has not found incriminating materials against the present accused. It's fairly submitted. It's fairly submitted that the investigation so far has not found incriminating materials against the present accused. The aforesaid facts and circumstances Request of justice demand that accused be granted bail by justice. Accordingly, allowed to go 15,000 with 170. Satisfaction of the
Chief Judicial Magistrate, Kamrup,
concerned
Metro and
manager,
Guwahati.
CJ and subject to the condition that shall cooperate with remaining investigation and not hamper or tamper the bail petition steps allowed and disposed of. Therefore, to this is done.
Yes, ma'am. We have next. May I take a leave?
No problem. Go ahead. So next one. Written 31. बोल के क्या हो? You want this, my lord?
For
AB.
please.
Say AB.
Everything. Okay, I never look at this case, 10 matter, 9 month, FIR month. The last person, matter. All together, matter, 9 persons were detained, including me, matter.
Okay.
And all 8 persons, other 8 persons were matter, rested. I was allowed to go.
Your name is?
My name is matter, Omar Zuti Meti. The number
Last one.
9. No, matter, Omar Zuti Meti.
No, yes. Accused number 9.
9.
Suspect
Nine.
number 9, whatever.
9. I'm not forwarding, but I have an Alex matter. All other 8 persons were arrested, they were closed. I was matter, COVID matter, no incriminating material has been recovered, found matter against me. It's another I was also detained, but that subsequently I was allowed to go.
All for questioning actually.
Matters.
Yeah.
And also the statements.
I'm ready to go, but when I'm so, but now what are they telling me?
It's going to be interesting.
Hmm?
It's with another person.
Huh?
Violations,
That's why.
statements.
No one can take law in their hands.
Yes.
I cannot kill a thief or even a dacoit actually,
Suspected.
except in self-defense. Self-defense, that too, that great scale.
Yes.
It's just, sometimes not very realistic.
So, balancing group of persons.
No, that's- Say- they have given that new provision for BNS, this, for mob lancing. Not, there's a new provision. There's a one, should I read the 164 statement?
Yes.
Flagged one?
The last one.
More duty meetings.
The statements. So there was 3 statements.
So I
It's a dictative statement. The process.
This is the victim statement, I think is not there.
Victim statement is there, but he has not indicated.
Yes.
He has not changed.
So I need to see another one.
That's a document.
Yeah, eyewitness. It is submitted by the learned counsel. That though the petitioner was called for questioning, but he was let off, not arrested. However, from the case diary submitted by the learned commissioner to SH board that there are direct adverse materials against the present petition. Drawing attention to 164 statement of one alleged eyewitness, they submitted that the present petitioner is stated to be directly involved in the incident. The bail objection of the IO also supports the same. And in fact, stated that from the CDR, this petitioner was found to be in coordination with another co-accused. It's contended by the IO that materials are indicative of a planned group assault. Now, the investigation is not yet complete, the present prayer for anticipatory bail stands rejected. Next. Can you tell me the item number, please?
Item number
Especially item
32.
Hero maybe.
My lordship. And she added a submission in this.
Hero maybe.
Europe maybe I am 41 days as on today, my lordship.
BN.
Be in my lordship. My lordship, the investigation has clearly against my lordship and my lordship, this petitioner demonstrably forced that the whole family is dependent upon the petitioner, my lordship. And petitioner is not involved, my lordship. He was a spectator, my lordship. He was working as a helper in one of the Khawgoli outlet, my lord. He was a helper. And my lordship, the other part that during this stay, my lord, in custody, he was initially they were interrogated, and during this long phase of 41 days, he was neither interrogated in custody also.
Police custody was taken in the beginning.
And thereafter during this process, he was which itself reflects that almost part of investigation is
In the context of the new law, this is a relevant submission. Quite relevant submission. That's order he was not taken. Earlier it was to be different. Quickly, 15 days gets over. So, would you like to submit to see the 164? I seem to have seen his name, but anyway, he's in custody.
He is in custody. He is a local resident, no past antecedents.
learned counsel submits that though the petitioner was initially taken in police remand and examined, but subsequently under the relevant provisions, his police remand was not sought for. This so he stated to be in custody since 41 days. It's 41 days. Third learned petitioner to just like that. That's
Or submission.
No.
Right, objection.
no. Who objects to the bail at this stage. I have seen that there is reasonably good progress in an investigation. Therefore, in view of the same and length of detention, it's allowed to go on bail, same terms, so that there's no confusion. 25%. Let him go on. Subject to the conditions, both the conditions.
Obliged, my lordship, I will.
Your lordship. Yes. Other two are similar footing. Similar footing, your lordship. 78.
78.
70.
Yes, similar to watch it for custody and 41 days.
41 days behind custody, your lordship. Both the petition. Similar footing like 30.
Learned counsel, as meaning. So, Mr. What is your good name?
Mr. A.N. Iqbal, your lordship.
Any.
A.N. Iqbal.
In. It took 9/8, arrested on 9/8. That's having good. 56 to.
Deeply obliged, your lordship.
Yes.
86 to 98.
Same thing. Anticipatory bail, as you know, stands in slightly different. This one. We don't know, so he may be required also. This is a good provision. It's lot of, there has been a lot of critical analysis, this new extended provision.
Yes.
But if it is not misused, it's a good provision for us in smart sense. Because Anupam Kulkarni, 15 days remains the same. Happens in my opinion, just and like this. That in the 15 days, the IO is under a lot of pressure. That whatever has to be customarily examined is. So if it is not misused, even a little longer time, it can reduce the risk of custodial violence. Oh, now we have many checks and balances. And it is not easy to get away.
Right,
But still, that is a reality to some extent. So it is not misused. But from the liberty point of view, there is one point problem. Is that a person will have to be in custody to exercise that power, to take him in remand later. So that can be, that will be one usual submission of prosecution. That police remand may be taken, may be needed, so he should not be granted. Whether it will be required in the future, that is also a bit of speculation. That is the anti-liberty part. But there's some practical utility. Let's see how it works. Initially, people thought that it will be 60 days police custody. One policeman told me that we will not be able to keep someone, we don't have space. Okay, no question. That will struck down unconstitutional.
Great process.
It's not his lordship. So, my lord, the petitioner is a juvenile lordship and he is underage. But police, without verifying his split documents lordship, and he is mentioned is about 19. Now he is in jail for last 4 months. He's over lordship. So only I have taken plea lordship and he's with his juvenile lordship. I have annexed some documents.
Which matter?
Item number 19. Therefore, application lordship. 1 line. I'll let you work at the not listed.
In between, we'll take it. In between, we'll take it.
Lordship. Obliged. Keep your.
19. No, maybe. 33.
Right? Earlier, just scan copy of case diary and receipt was called. Then search it was called.
Not received. Not received.
Can it be on prior to vacation or if possible? He's from Kamrup Lodge, Kamrup Metro.
Lady's bag was stolen, containing valuable items.
Yes.
2-3 incidents, lordship together, they have clubbed up and the FIR has been filed.
9-8. Theft offense, right?
Your lordship.
Yes.
Lordship, lordship will appear lordship any condition lordship. That is, a
Scan-
matter has already been charge sheeted lordship.
AB or bail?
BA lordship. Already charge sheeted 41 days behind a bar.
Scared of you before.
Where will you appear? Court.
Lordship,
Appearance before court.
court lordship.
Or
I'm seeking bail lordship, not disposal.
Hmm?
Already behind a bar lordship, that I'm saying now trial process will commence lordship, that appearance I am saying that any condition lordship.
no, but
Scared
PCR,
since it was already
Lordship,
scared of
lordship,
at best we can give some
Right.
intervening protection.
25th lordship,
23.
or lordship, lordship.
Will it be possible?
Lordship.
No.
No, not 23,
23 of this month.
or lordship,
No,
lordship.
no, I didn't say this actually, but
It's-
isn't it from which court? GRPS.
Yeah, yes.
But next week, we have to be careful because already overloaded actually. Not, so anyway. 483 bail application seeking regular bail for 4 accused persons.
Lordship.
Arrested on 9/8/25 in connection with GRPS case 122 of 25. Under section so and so. The allegation in the FIR. Containing elaborate details. Is dated 9/8/25. And the allegations pertain to theft. Stop. We have been said to be a gang,
Yes, but
said to be a. However, the case is charged sheet pending for receipt of scan case report for this bail adjudication. Learned additional PP opposing the bail submits that is not yet received and seeks another date which is allowed. So issue for fresh requisition for the scanned copy of case diary and charge sheet. However, considering the length of detention and the applicable statutory period. In the interim, the accused persons are allowed to go on bail about this 25,000 each. With the surety of the like among each. The satisfaction of the concerned learned court, subject to the conditions that they have been summoned over. Notice.
No. They are inside the jail lodge. After their
No,
arrest, charges.
No, they have been produced before the learned.
Lordship.
Subject to the conditions that they shall not abscond, semicolon, not indulge in any offences and cooperate with the trial. So then we can fix it after vacation. Or not. Can fix it after vacation. This is the matter after vacation on You can suggest,
27th of July.
can be early also,
Also
17,
17.
17. Because by the time, but 413 might be there, 413 habitually, then it will be 90 days. Otherwise 60 days will be over by the time vacation is last. That's why I'm doing. Much obliged, much.
May I please ask?
Yes.
And it's a regular bail application, madam. And the petitioner, my lord, he has been arrested, my lord, on my lord 9/7/2025, and as on date, my lord, 73 days he is in custody, ma'am. So here is the case, my lord, you'll also will kindly come to page 14 is the FIR, madam. In fact,
Kidnapping and some,
yes, in fact, that is completely a concocted story, my lord. And the informant who is a married lady, even she has not disclosed her age in the FIR, my lord. That is kept blank, my lord, in the FIR itself, my lord. You'll also will kindly come to page 14, my lord.
yes.
I am writing to lodge a serious complaint regarding a criminal incident that happened with
Yeah,
Mrs.
I remember.
Yes, yes. In fact, my lord, that is
Injected with something in that.
Yes, yes.
Allegedly.
Yes, madam. Third line, and in fact, this FIR has been lodged after about 15 days of the alleged occurrence, man. After 15 days, man. And this is not explained in the FIR itself, man. And in fact, in the FIR itself, it is stated that, she, came voluntarily to the, accused persons, man. And
But,
in fact, yes, madam.
I think we had seen the CD once, no? So did we?
I
Because the story is familiar to me.
We have received a case diary, but the statement of the arrested accused is not in the part of CD.
Page 8 lordship, that's right, lordship. That on a diversity party, yes, lordship. That FIR is different lordship. I am not disputing about the FIR lordship. From the Guwahati lordship, from Guwahati Siliguri lordship, on the road of the local lordship, yes, I am not disputing lordship. I am lordship on a labor of a sand carrying track lordship. My house is a district lordship. And on lordship on 23 lordship, on the day of my arrest lordship. While I came to Guwahati lordship as a labor of in my vehicle lordship, then lordship had recently in Jorabad lordship and police arrested lordship in Samo lordship. How they disputed lordship, how they suspected lordship, I don't know lordship. So lordship, I have no any connection to that aspect, to the FIR lordship, to the incident lordship. I don't know about anything lordship. And my forwarding report lordship, my allegation lordship, ground of arrest lordship, can be seen lordship, page lordship 13.
I'm just seeing this.
Yes, lordship.
His name is?
Mohar lordship, Mohar lordship. Please.
It's here.
Yes, lordship. There is no whisper lordship that I was involved in that incident lordship. And only this I was assembled with some person in the Jorabad lordship, that's why I have arrested lordship. And how they got the connection with me lordship, with the said FIR lordship, the incident lordship, I don't know lordship. Okay. So lordship 6,200 behind the lordship, can be considered lordship as the issue. And lordship, there are FIR says lordship 5-6% of their lordship in the said incident of the Boromo lordship. And already lordship police perhaps arrested about 20% lordship. Lordship, how their lordship connected lordship, all of them lordship, I don't know. FIR says only 5-6% of their lordship, maybe their lordship. And prior to arresting me lordship, they already about 10% arrested lordship. And only my group lordship, our group is lordship, in this page 16 lordship, this 10%. These 10% were the lordship assembled in the lordship in Jorabad. And they are lordship divert and other labors lordship. And they also suspected and this connected this lordship.
Mohar Ali, kindly see.
Mohar lordship has regarding involvement of the Mohar Ali. Other co-accused may have stated that Mohar Ali is associated with them. That is regarding other co-accused statement.
Apart from that,
Apart from that, I have not done anything, but other co-accused statement.
that he was also part of the gang.
Yes, yes. That's the same. Is it kind of that Bawama highway, property?
Yeah,
Yes.
yes, matter actually. What is the progress of investigation? Looks quite voluminous.
Investigation is going on.
Progress. Progress is there. As per the forwarding report, he and the others are all habitual offenders.
Regarding habituality, I tried to check out how regarding other accused persons, there are Azimuddin and many other accused persons, there are a long list of cases. But regarding the present accused,
Who says mine? I do not know, Lordship, but whether the main accused, Lordship, who are the actual culprit of the offense, Lordship, whether they said or, Lordship, the accused of the Zorabat, Lordship. I do not know, Lordship, actually, Lordship, who are they are the two different groups, Lordship. In Zorabat group, there is another group, Lordship, and in the main Boroma group, there is another, Lordship.
As Hope, learned counsel, as a Hope, right, yes, as a- for the accused. Mohor Ali, alias Mohor Ali, seeking bail in connection with Boroma PSK 61 of 2022. Under section 310 subsection 2 means. The allegations in the FIR dated 16/7/25 in a gist is about dacoity on a truck carrying pan masala worth more than 80 lakhs. It's stop. It appears from the forwarding reports that part of the alleged stolen property has been recovered. The present accused was arrested along with several other persons at Jorapat near Guwahati and allegedly involved in the offense and were forwarded by on the same day. The learned additional PPP bottle submits that case diary has been received. And the implications against the present accused is the statements of, is the incriminating statements of the co-accused about the involvement of this accused as well in the offense. The learned additional PP fairly submits that upon perusing, he did not notice other incriminating materials against the present accused. And no specific details have also been mentioned about him regarding any allegation of being a habitual offender. The statement of co-accused in an alleged offense of this nature bears its own relevance. However, any statement of a co-accused also necessitates critical scrutiny. Considering the aforesaid facts and circumstances and also the fact that the accused is in detention since 23/7/25. Dash, he is hereby allowed to go on bail of rupees 30,000 with one surety of the like amount to the satisfaction. He's a labor.
Yes, Lordship, labor.
30,000.
Yes, Lordship.
30,000 with one surety of the like amount.
Senior Baksha,
To
Lordship.
the satisfaction of the concerned learned court, CJN box, and subject to the condition, number one, shall not abscond. Number two, he shall cooperate with remaining investigation. Hamper or tamper with evidence, and he shall not misuse his liberty to commit any illegal activities or offences, including any offences pertaining to property. The return the case diary, where petition stands allowed and discussed. Just record his objection, not an addition, objects to the ground of law.
So 49 is of the same case there. And this is where Lordship, updated case there was called for last.
Same case?
Yes, sir, same case. It was updated case there was called for Lordship.
49, my lord, petitioner is in interim manner.
There's an interim update.
However, I have not found in the case where the statement of the accused, but there is a regarding the present petitioner, there is a note of the IO, my lord. I would just like to point out, my lord. It is also seen in the honorable court also dated saying so while granting interim, my lord. Wherein the petitioner from accused, potentially the present accused, is misleading the court by projecting himself as the victim driver of the truck, and that his hands and mouth were gagged. In fact, my lord, he is not the driver of the container truck that was hijacked, but he is the driver of the pickup truck which was involved in the dacoity and used to load the looted goods. And there are other materials also against the present.
Can I have a look at that note?
Yes.
So that gagging was a story.
Yes.
According to this note, according to the IO.
My cash diary में अपने along with my statement में काम करना है.
What is the statement? What is this? Same thing.
It is not statement, statement version.
Huh?
But my last person.
Person also might be involved, but it's only co-accused statements are there. So been in there. for some-
First page. Regarding the while we trying to solve all these problems. First order did five
Last
times.
portion.
Yes, one statement about hotel virus. Someone identified while he along with identity money went to solve those problems. Also, can you order data 5.25 may be seen lordship, here lordship, updated case data was called for along with my statement lordship. So lordship, they may send lordship what my ground lordship have stated in my before the police lordship. That may be called for lordship.
What his statement? His statement is here.
But then this is not my statement.
No, no, I can check.
That may not be my statement lordship.
Check.
From this note,
Yeah.
to clear statement of the otherwise.
Yeah, that's true.
So the note of the police lordship. It is updated.
I don't know what to do. 1, 2, 3. There are 5 others in 18. The case diary as called for has been received. Learned additional people, P. Bhattakur submits on the basis of the case diary that though the present petitioner was stated to be a victim and driver of the truck who was which was looted by dacoits, and he was left at another place slash Bhavanipur. Left at another place, said another place after gagging is not dash that but investigation revealed that actually he was one of the assailants who was driving another pickup truck which was involved in the dacoity of the truck carrying Pan Masala. The upon being pointed out by the learned traditional people, peruse some of the statements of witnesses, also which lend support to that contention. The petitioner, the present petitioner was granted interim bail on 18/8/2025 on the basis of materials existing then. And the investigation is, as the investigation is not yet completed, therefore, it would be prudent to cancel the interim bail and reject this petition. Accordingly, the interim bail is vacated and the present petition for anticipatory bail stands reject. Return back the case then. Petition disposed of. He might have given you that instruction.
My lord, this is the second occasion, my lord, case diary not received, my lord.
No.
Otherwise, my lord, allegation only against the petitioner number 1, my lord. There is no allegation against the petitioner number 2, my lord. Then also, my lord, petitioner number 2 and both are behind the bar for 32 days and 31 days, my lord.
It's from Surya.
Case diary has come? Not received.
This is the second occasion, my lord.
So if the case there, at least we try to police the case before vacation. Priority vacation.
Case diary not received. Case diary is not received. Stop. Issue reminder. For the same, issue reminders for the same. Fix on
25/9.
25 minutes. For
My lord.
failure.
My lord, item 61 also,
Same.
same affair, my lord.
Same
In-
file.
Item 61, we are in interim.
Just a
my lord.
minute. Just a minute. 61. AB, no, this is not an AB, this is a BA. 61 is also, is
Yeah.
a AB.
AB.
In time of
Interim was there.
Interim was there.
my lord.
Look up 61. 61, okay, one. Case diary is not received. Issue reminder. The interim bill granted by the order dated, dot, dot, dot. Standard till the next date of listing.
What are the 8, 9,
Same
20?
thing.
20,
Department.
25/9.
It's scheduled to be done.
Obvious, my lord.
25. Yeah.
Eighty-four, 91, 87, and item number 1 on the personal case also, all of same, arising out of same affair. Because the city is total of super.
What's other matter, no? Child, PWD official. Then together, you keep it, huh? After something. Which are the item number? Can you-
Item number 1 of the motion list.
One.
Item number 1, 84, 87, and 91.
One order has been reserved and passed today only.
That's one.
Your CD is, you have you got this? Oh, no, you got it. Can you bring this CD to?
Hi.
Page 9 is the FIR lordship. So between place owner and employee lordship, lady employee. She was working in a accounts department lordship. There are some misappropriation of fund was there. She was fired up from the job. And thereafter subsequently this FIR has been lost by them, saying that physical lordship. Page 9. Oh. I see. In the meantime, also, he was arrested after lodging of the FIR and charges have been filed. Actually. And the further custodial detention also might not be required also because the allegation, considering the allegation also. And I have already categorically stated in my petition regarding the misappropriation of the fund lordship that lordship will find on page.
Can copy receipt, but we have not gone through it. So sometimes we allow us to go through it.
Statement of the investigation is completed.
Lordship, charges.
Scan to that's what we try to go records.
They have come. Just to.
Actually, the statement lordship once it will remain the same lordship. The other witnesses lordship will not be there because they were two alone in the room.
When was he arrested?
Arrested on lordship, 5-9. Local person of the same,
checking the narration. What is the document from your side about that alleged misappropriation?
no, that immediately it happened, lordship, so we could not, annex the one lordship, that, only thing, she was fired and she was asked to repay the misappropriated amount, lordship, that may be after 2 days, the FIR has been lodged. And in the FIR itself, says that she disclosed to the wife, lordship, but the wife did not read it.
Anyway, it's a question, kind of go through it. I just take your time, but one thing is that in the narration in the fire, that Ayu has mentioned about this case. He's given the number where it was lost by the same person, same lady, alleging attempts to molest.
It is another person.
Same person,
Same person.
same informant. But anyway, if you don't know about it, so you have a look. We'll see properly after some time. Just
What has been called?
after some, after some time.
Lordship.
Fixed. So.
May I please? My lord, I was in interim, my lord. I have appeared before the investigation agency and finally submitted successfully. FIR is at page number 9. So investigation is over. my lord.
Started submitting.
That's not. Let's do that, let's see. The, on 19/7/2025, this petition was granted the interim day, pursuant to which he is stated to have appeared before the IO on as submitted by the learned counsel. Full stop. The prosecution submits that in the meantime, investigation is completed, resulting in a charge sheet. In the situation, the interim granted right order dated 19/7, hereby made absolute, subject to the visual conditions and available for the petition stands allowed and dismissed.
Hello.
Next. The warrant.
Wait, please, lord. My lord, the matter relates to the abetment.
FSL is.
My lord, I'll just tell you the facts of the case, lord.
Yeah, go ahead.
My lord, what has happened, my lord, in this case? My lord, the deceased who committed suicide, my lord, has taken money on loan, my lord. Your lordship will kindly see, I have annexed those documents that is at page 23, my lord, onwards. I'm sorry, page 19, my lord. Page 19, your lordship. will
Should I
kindly-
see the Azahar ones?
First, Azhar, my lord, okay, okay.
I'll quickly go through
My
myself.
lord,
I'll myself go.
Yes, sir. The split. Well, you can lordship can go for the vernaculars also, that is at page 16. Vernacular will be better for. So, my lord, your lordship is that the deceased is the Procedural Chakravarti. My lord, what his wife has said because of our repeated demand, so he committed suicide. Now your lordship will kindly see there, he is my very close friend, my lord. Lordship, page 19 may kindly see. Page 19. See, on February 2024, that is on 5 February, 5th February 2024, that I have from the above, my lord, 1, 2, 3, my lord. Kindly see, he has taken loan, Prosenjit Chakraborty, rupees 5,54,000. I have paid because he has some, we are very good friend, my lord.
So the deceased and the accused were good friends.
My lord,
The deceased and the
yes,
were
sir,
good
he's
friends.
a very close friend, my lord. So he needs the money, is in the trouble, my lord. So your lordship, kindly see, this is the bank statement, my lord, on 5th of February, my lord. A amount of through bank transfer, I have given 5,54,000, my lord, to him. That is at 8 pieces. Then again, my lord, kindly see, again on, next, my lord, page 23, your lordship may kindly see page 23. 23, your lordship, you got page 23, my lord?
Yes, sir, I'm on 23.
Then, my lord, your lordship, can we go, the date of 33, 2003, 24. 33, the dates, my lord.
Yes, I've seen.
That so and so to
5
Prosenjit
lakhs.
Chakraborty, 5,20,000. Total, he took me 11 lakhs. And he said that now when I was in trouble, my lord, because my wife got a stroke, my lord, I demanded the money. Definitely, yes. Any person who is given a money, he'll I'll demand his money. So can it be, my lord, rope under, my lord, abatement, my lord? And lordship kindly see, then your lordship kindly see, before his death, my lord, he issued 2 checks, my lord. That is at page 24, my lord, and page 25, my lord. Kindly see.
The
24?
checks bounced.
No, I could not, my lord. I lost, my lord, the entire money, 11 lakhs, which I have given, my lord.
Oh, this is
And-
a check issued by you.
Not by me, my lord. By the deceased, my lord, before he died. 3 days
Oh,
before, my lord,
so-
24, Keshav Burma, my lord. Kindly see.
No, that's why initially I thought that only.
Ah.
That these checks were, could not be encashed,
No, my lord. I could not encash, my lord.
bounced.
Not bound, my lord. I have not placed it
Oh.
there before this, sir.
In the meantime,
And he
this incident
committed,
happened.
kindly say he 26/5/2025 he has given, and he committed suicide on 29/5, my lord. And Azahar was filed on 2/6, my lord. So, my lord, suppose if I take a loan from a bank, I could not give, if the bank demands me that whether it's a case of an abatement.
That's a very, that's become a very,
No, it's a common thing, my
it's
lord.
become a tricky section. It's abatement.
No,
It's
tricky section in a sense, the lordship kindly see, tricky section so far, suppose 11 lakhs is not a small amount, it's a huge amount. You have taken, that is on the records, it establishes he has taken money and issued check also 11 lakhs. Now, the question is that, am I not demanding? If I have given, will not I demand this money from him, which I got it? I help him and I have, and consequences now, I am before your lordship.
That is what I
And
meant
petition
actually.
number 2 and 3 are the sons of petitioner 1, my lord.
The idea is, no, that is what I meant by tricky section. Actually, many cases of abatement to suicide are coming where you have to see whether the linkage is made out. That in that sense, many people have been roped in under this section.
My lord.
But it remains to be seen whether the linkages are made out or not. Every suicide, many suicides are leading to this case, this filing of this, invoking this provision. Anyway,
No, anyway, but
that's
here is a case is just exceptional, my lord.
you have placed some materials, definitely, no doubt.
It's a material.
Support of your case, no doubt. You have made out some case. Let me just see.
Yes, I had received two cases, PM report, received a personal report noted receipt and regarding the one suicide note, is available in the case like suicide note, the picture different picture, please.
His statement must have been recorded. no? Because he was
statement is
granted
recorded.
interim basis.
Statement recorded, my lord.
You want me to see or you tell me?
The suicide note of the victim deceased.
That is, there is not disputed, so far the suicide note is concerned. The lordship has to see my statement also.
Regarding the authenticity of that suicide note that was sent to FSL.
That has to be seen out.
No, that is undisputed. The person has died,
And
person
I
has
think
committed
that has
suicide.
to be- Yeah. He has also said that your friend
My lord, yes.
11 lakhs was given.
He has been given on 2024 and he committed suicide in 2023.
Sit down, 5 minutes ago. Order to 1970. Learned senior counsel, assistant. Uh, well,
Himanshu Sharma.
yeah, no problem. It's fair. The FIR giving rise to this case was lodged on 2/6/2025 by the wife of the deceased, alleging that due to mental torture inflicted by the FIR named accused persons, her husband committed suicide. On 19/7/2025, the petitioner was, how many petitioners are here? Three.
Two and three are the sons of case number one.
Three petitioners were granted interim 3 years day with conditions. It is submitted that pursuant thereof, they have appeared before the IO and examined, which is also confirmed by the learned additional people, P. Potaku, who submits the case diary before me. It follows the suicide note of the victim as also the statement of the accused. Learned senior counsel for the petitioner side has drawn my attention to some documents indicating, reflecting bank transactions by way of lending of money to the deceased. The amount of rupees 5 lakhs on one occasion. Copies of 2 checks. Copies
There
of
are two, 5 lakhs
checks.
and 5 lakh 45. Totally 11 lakhs.
The deceased has also stated in his suicide note about rupees 11 lakhs. 2 checks purportedly issued by the deceased by way of returning the money have also been annexed. Nevertheless, in the given facts and circumstances, whether any alleged acts of the petitioners amounts to abetment of the suicide of the victim would be a matter of full investigation and special evidence if if a trial starts. Nevertheless, in the present situation, I am not inclined to cancel the interim bill, and therefore the interim PRS bill granted by the order dated 19/7 is thereby made acceptable, subject to the condition that the petitioner shall not hamper or tamper with evidence and shall not cause any harassment or harm to the informant and her family. Return back case that the execution stands allowed and disposed. Which 41?
Yes, sir.
Why?
41 civil not receivable, petitioner is in interim.
Can you extend the interim notice?
That will be extended. So, after vacation, CD, case diary is not received. The learned counsel,
D dash.
he does submits that the petitioner is on interim and seeks extension of the same. Issue reminder for case diary, interim bail granted on 21/7/2025. Shall stand extended in the next date of listing. It's on 24/10. Is it okay? 24?
So lordship, I'm on interim, your lordship.
Hmm. 23/7, 2024, first two variants. In the same date, on 23/7/25, the petitioner was granted interim anticipatory bail with conditions. She appeared,
Yes, yes.
pursuant to which she is stated to have appeared before the High. However, the prosecution submits that investigation is now completed, resulting in a charge. In the said situation, the interim bail granted by authority is hereby made temporal available for trial. Disposed of, allowed and disposed of. I know.
City not received, petitioner is in interim.
Please, Miller, I'll extend it after vacation. Yes.
Only serious, that's serious, not been sent.
So you want to get rid of it.
Okay.
No, no, I'm saying
Okay, Miller.
you want to get over with this bail petition.
Hmm.
That's understandable. Understandable. So these days will not be realistic.
Okay.
Overload. The case diary is not received. Issue reminder, interim bail granted by order dated 29/7 shall continue the next date of listing. List on immediately after vacation.
Yes. 17.
So let it be, we are reopening on 13th. Yes. Let it be on 13th only. Or 15th, 15/10
Yes.
1510 already.
after puja. 15/10.
Maybe lordship. The pre-arrest bail application lordship. Petitioner is on interim bail lordship. Lordship, sections involved are lordship 3032, 317(4), 324(5), 35 of the BNS. Lordship. Earlier lordship 379, 413 IPC, and lordship mischief and common intention lordship. Lordship, the allegation is that the dumper vehicle of the complainant was taken away by 4 persons named in the FIR with the help of crane vehicle. And later on, it was alleged that the same was cut in the lordship scrapping shop. And lordship, I am a lordship scrap dealer by profession, not named in the FIR lordship. I have cooperated the investigation. I have appeared before the IO lordship.
One of the prospective purchaser. Otherwise, the letter is one big
Prospective purchase.
Prospective purchaser.
Yes, that dumper vehicle, that dumper vehicle was cut into pieces.
No, as a scrap.
Yes, they are step them parts by part, engine, another various parts later on, number one. Other many accused persons,
Some were arrested, some were released on bail. Prospective purchaser, but could not purchase lordship.
Should I see? Or sufficient? But if true, the conduct is very attempting to. No, again,
some
these kind of offenses are, alleged offenses are increasing. Anyway. First date of first one. 7. Last 2 hours. The petitioner was granted interim bail on 31/7/20 pursuant to, with conditions. He has appeared. Pursuant to which he appeared, the I1 statement was recorded. The learned additional people opposing the bail submits that the investigation has revealed materials indicating that the petitioner was trying to buy the dumper vehicle in the form of scrap after it was allegedly broken up by the other accused. The same submission indicates that investigation found incriminating materials against this petitioner as well. And or being involved in some of the alleged offences. Nevertheless, since he has been granted interim bail pursuant to which he cooperated with the investigation, therefore may not be necessary to cancel his interim bail. Accordingly, the same is made absolute. With the conditions that he shall not hamper or tamper with evidence and shall not indulge in any illegal activity or offences. In case of violation of bail conditions, his bail would be liable to be cancelled. You can file an application if there is no violation.
Keep your pleasure.
Allowed and disposed. The proceedings.
Maybe.
46, civil law procedure.
Third occasion, my lord, CD was not received. My lord, may kindly have a look at the FIR, my lord. That is page 11, my lord. The allegation is the 9 number of batteries were stolen, my lord. It was recovered from one Abbas Ali, my lord, that I have annexed at phase 14, my lord. And he has been enlarged on bail, my lord. And batteries are already been recovered, my lord, and that has been given to the informant also, my lord. My lord, this is my custodial intervention may not be required, my lord. I have also indexed the Jimma order, my lord, that is what you will find at page 15, my lord. Everything is recovered already, my lord. Custodial intervention may not be required, my lord.
You said CD is not received. CD will be necessary.
This is third occasion, my lord.
When can you get it? 25. Tuesday is not received. The learned counsel, petitioner counsel reiterates his prayer for pre-arrest bail. However, issue reminder for the case diary fixed on 25. We'll have a this. 47 6 submitted in this case.
Yes, Lord. I am, all the petitioners are in interim. Already appeared.
14/8/2020. First two times. The petitioners were granted interim pre-arrest bail on 14/8/2025. Submitted by prosecution that the investigation is completed, resulting in a charge sheet. Accordingly, the interim pre-arrest bail granted by it. Is it now diaries receipt or only charge? No, we cannot say whether, because that was one aspect why interim was given, that it may be a counter blast also. But since we don't know, investigation is complete. Still, since interim has been given, cancel it. Subject to the condition that, made it absolute, subject to the condition that second condition will be taken. And they shall be available for the trial if one commences. Number 3, they shall not misuse their liberty to commit any offense or illegal activity. Petition stands allowed and disposed. Doesn't.
May it please your lordship, item 15 will be timing lordship, series on legs lordship.
Two time. Next. Rama.
53 and 54 same. I think out of the same fire.
53 and 54.
Oh, yes, Lordship. So I'm on interim in both the matters, Lordship.
Auction, 3 matters are there. No. 4 matters.
Finally, this matter will pass over to the county. My learned friend has gone through the, my learned friend has gone through the scan petition, scan to receipt.
Okay. After some time, need some time.
Application. 56 is a regular application. I'm the behind the bar from the last 61 days.
Should I take up the AB first or BA?
Lordship,
No. Let's take up the BA first.
yes, ma'am.
It was same thing, I'm taking up together. He's in custody since.
From last 61 days, my lord. I was arrested on 21st July 2025. I'm not an FIR name accused.
61-2, no?
My lord.
There is receipt, it seems.
Diary receipt.
Just a minute, let me see the FIR ones.
Yes, my lord. The vernacular portion is at page number 20.
See that translated only. The present petitioner is Monowar.
Yes, ma'am.
Monowar.
Monowar Molla.
Who is he? 4 are named.
Yes, actually,
His wife is named.
his wife is,
He's the father-in-law of the deceased.
no.
Brother-in-law.
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 Can you see? He stayed, same house he stayed, no.
No, man, he's not saying a different house. Different house, my lord. On 17th, my lord, police called him, and he has
Arrested.
he has appeared before the
Okay,
IO, and on 21st he was arrested.
okay.
You only put this, opinion to cover the pending, because and so I sent it to the bank, opinion of the pending. Regarding the petitioner of stories of the FIR, saying of but regarding the petitioner has only 1 2 years of it. Why is taken into the her name accused of Savita Lakshmi is the sister of the main accused. And regarding a trace, yes, we taken the disease not looking within that I will finish your medical career. Because I have one of the statement of the witnesses. That part is your.
I have no role in this case, my lord. Already at 61 days, my lord. We are given.
And what is this, AB is filed by?
AB is the father-in-law, mother-in-law, and sister-in-law.
Father-in-law, brother-in-law, sister-in-law.
Father-in-law, mother-in-law, sister-in-law. Well, the victim lordship is already at the FIR, my lord. The deceased is, my lord, Momina, my lord. And she was married to Najibul. Najibul is the husband, my lord. He is not before your lordship, my lord. He has also been arrested. And now petitioner number 1 in the AB is the father of Najibul. Petitioner number 2 is the mother of Najibul. Petitioner number 3 is the sister of Najibul, and who also happens to be the wife of the petitioner in the regular bail application. So one of the things, my lord, in the FIR,
Just a minute, let me just absorb the thing. Petitioner number 1 is the father-in-law.
father-in-law of the deceased,
Petitioner number 2, mother-in-law.
mother-in-law.
Ulmati Begum. And Shahida is
Shahida is the sister-in-law,
their daughter.
their daughter,
Their daughter.
their daughter, who happens to live in a different house, along with the petitioner in the regular bail.
You can make common submissions. You want to complete
My
the
lord.
submission? Yeah, do so.
So in this case, one of the informant has alleged that we have committed, we have killed her. That is the allegation is of murder, my lord. Now, subject to what is there in the case, there is, because my understanding is quantified that the FSL is not sure. But if the postmortem report is there, if it can be said that whether the case was homicidal or suicidal, because it is our instruction that the victim had committed suicide. And the petitioners before your lordship had taken her to the hospital and had informed the father, my lord, the informant. The informant is also represented here, my lord.
Appearing for informant.
And we had informed them, my lord. That is also there. So we come to know that deceased commits suicide. If she is hanging herself, we take her to the hospital and we also inform their family members. Now, we do not know why the informant, perhaps they can also enlighten the court, why they have made the accusation of murder. If we are somehow responsible for her suicide, they could have accused us of abetting her suicide, but they have accused us of murder. And we do not know, madam, what had transpired between the husband and the wife. What are the circumstances which compelled her to take this drastic step, and unfortunately she lost her life. But that is something which was between the husband and the wife. Now, if they are living in a family, joint family, obviously there must some friction may always be there between the father-in-law, between the mother-in-law, the in-laws, and the daughter-in-law. But it all boils down to whether these persons were in some manner or in any manner responsible for causing her death. So on that aspect, my learned can enlighten this honorable court. If there is anything to show, we had compelled, either killed her, which is, my lord, as per our instructions, not correct, or we had abetted her suicide.
As far as the statement of the informant, I have no role. FIR is totally silent regarding my involvement.
Your wife is named,
Wife,
but no, nothing,
regarding
no allegation.
yes, ma'am. Totally silent.
That's right. It refers to the FIR named persons.
And
But,
this, my husband and wife, they live separately. my lord.
Forwarding report. 61 days, right?
61 days. 20,
Forwarding report is here. The next one. Wait, when I think. Oh, yes. Monoar, 36 years. I'll. Grounds for next.
But that part was silent, but with
The family or the informant whom you are representing, their contention is that she was murdered, killed.
and all parts. We plan it was just one day of murder.
So, Learned, if you can enlighten this court, if their contention is correct, or whether this is a case of suicide. If it's a case of suicide, then their allegation is evidently false.
So if the statement of forgery and statement recorded. This is indicated then that yes, sir. Frequent
Just
queries-
increase the volume. of the mic. Microphone.
frequent queries are there in the enter the feminine person, they assaulted her mentally and physically also. Demanding from dowry parties, they are a statement of the witness appropriate. And one day regarding a gold chain, they are the between the mother-in-law and the sister-in-law at the police worship. So later for lordship, in his confessional statement, the husband, the main accused Nadeem, he stated that yes, when 12 took place, he with anger also he hit her in her chest, she fell down. Later on, he went away outside the
Husband.
husband. Then when he returned because his home, he found she was dead. So apparently nothing to do with he has that. Appeared to be dead.
No, yeah, fine. And this person, he says that the informant says that he's the
Whole community state
mastermind.
with all circumstances also. Every day they were, as far as statement witness concerned, statement of the witnesses. Every day, the whole community is creating a situation against harlots. That's why the incident took place. So regarding the AB, I have objection of it because one thing is that the EA part of it.
What is the investigation?
Only the allegation.
What is the investigation say about this father-in-law, mother-in-law, sister-in-law? And why, and matlab, this father-in-law, father-in-law, mother-in-law, and third sister-in-law with the wife of the accused who's in custody.
Yes.
So against the people seeking AB,
AB.
the anticipatory bail,
That,
what are the materials?
Materials,
Allegations,
all-
whole family,
whole community.
including this arrested person.
Arrested person, only the allegations are as per one of the statement of the witness, he stated that he threatened her. That he will finish the relationship between us, they are all husband and wife. He frequently, as per the statement of one witness.
One of those two responses, my lord. One thing which my learned friend has again not submitted, whether the death is suicidal or homicidal. Because your lordship will examine that as
Prosecution or informant?
the informant is saying, my lord, this homicidal,
No,
but they would have no.
Okay. The medical, the PM report, does it
PM
indicate?
report is pending also. It was episode report not received yet, that's the date of, the plate is pending, still pending.
Okay. Viscera was sent,
This was.
but allegation is not a poison or something.
Not a-
Insecticide, poison,
Yes.
it is not that. Does the PM report indicate ligature on the neck?
Ligature for, yeah,
Then it's a case of either
Suicide
suicidal or homicidal hanging. Forensically, it can be, they can express an opinion. So the direction of the ligature is different.
continuous and not.
Both cases. So that it can
Because
be.
informant would not have seen the incident, so only the postmortem report can
Yes.
reveal.
So the materials are indicative of suicide
Yes.
as of now, more indicative of.
An oblique, ligation mark, an oblique, non-continuous ligation mark of size 24 cm was present high up on the neck above the level of thyroid cartilage. The non-continuity, that was the position of the knot being situated immediately behind the angle on the mandible on left side actually. That is non-continuous part is here also.
There will also be some kind of a fracture too, right?
If it is, my lord, oblique and non-continuous, then it is indicative of a death by suicide, my lord. If it is continuous, then it would be.
Only one piece of part is here in the postmortem report. An inquest report, injury was that a bump was found on head behind right arm during infection. But one can go to the statement of the main accused husband.
Husband is not here, your lordship.
Not here, but he.
Husband is not an accused.
My lord, one of the things which I would like to submit, my lord, is that whatever my learned friend has read out from the case diary, what it indicates is that assuming those allegations are absolutely correct, then it only indicates a case of cruelty, my lord. It only indicates a case of cruelty. Now, the only thing which your lordship will examine beyond the allegations of cruelty is whether the petitioners were responsible for her death.
Abetment.
They are accusing us of murder. That the postmortem report. almost-
108 is there, the section.
No, it's not there, man. It's
It's not
103, not there. So postmortem report belies the allegation of murder. And whether if also, my lord, your lordship knows, my lord, abatement has its own parameters, my lord. When abatement can be there. So just because there is.
Difficult parameters.
Yes, ma'am. Those
Typical parameters.
those parameters will have to be there. So just because we are accused of harassing her, my lord, true or otherwise, it only makes out a case of cruelty, does not make out a case of either murder or abatement of suicide. Now, postmortem report, FSL, my lord, whatever it may come in FSL, at least prima facie, my lord, the postmortem report. Postmortem report suggests it's a case of death by suicide, man.
Anything else to say from your side? And killed her.
And try to change the mechanism.
They were not there. That is even in our family members, 2 persons were killed earlier, man.
Lot of conflict. That's true. All these things are, because, I think I've not
Regarding
understood.
one of the enforcement, the earlier order.
Yes.
My lord.
One thing I have not understood, as of now is that this Chand Sheikh, Akiro, this 6 persons were found to be,
yes.
validly crossing into Meghalaya through this outpost.
Regarding, accused were not there, only one accused.
But these persons are not accused.
Yes.
only
If I kindly come to paragraph 3.
Sahid Sheikh.
Yes, Said Sheikh is also one of the accused, but
Yes.
he is not the petitioner in the present case, my lord.
Yes.
One statement made by the petitioner in paragraph 3, my lord. Page 5, your lordship, 11 portion is. On 5. Page 4, my lord, last portion, my lord. On the release date and time of occurrence.
Petitioner 1 was engaged in
Narcotic duty from. Further, the petitioner number 226 were at Borpeta Road Market. Moreover, on 29/7/25 at about 9:30 AM, the petitioner number 327.
3457.
3457.
We were
Because of that,
proceeding towards Meghalaya. In a vehicle bearing registration number such and such.
This photograph, these are not accused.
this is not accused. Because-
Except one.
Oh, yeah, except one. So except one is also not the petitioner in the present position.
Understood.
So the statement is false. Now.
Anyways, can I have a look?
Well, PM report or PM report is, has wait for some time to getting the death negative letter of the IO.
One is on interim, right?
One is a ranking.
If you have no problem, I can wait. I have no hurry to dispose it of. But since sir has been saying, it's pending for some time. No, if we are keeping it pending for the PM report, then I will not go into it much because of time constraints.
This is not a fit case for anticipatory bail.
Let the PM, the honorable court wants to produce the PM report with.
No, I just asking, sir, should we keep it pending?
Consider the materials right now available. Only
Uh,
basis of the materials available in the court.
The learned additional PP Mr. P. Potaku. After receiving the case diary submits that there are significant incriminating materials and that it is not a fit case for grant of pre-arrest bail. However, the PM report as called for has not been received and he submits the communication of the IO seeking some time for the same. With regard to the direction from the court about crossing of the accused persons on the relevant day to an outpost in Meghalaya. And wireless communication, an investigation was done into that aspect and a wireless communication has been annexed with the report in which it is stated that except for Sahid Sheikh, CHID, Sahid Sheikh, no accused persons were reported to be present through spelling to JWMA WROH infiltration check gate Meghalaya under Rani Jirang outpost Meghalaya. It is also stated that no outpost by the name of Sukur Birya outpost exists. Was found to exist along the Assam Meghalaya border. Would you like to retain the CV or?
I return it, then we will kind of fix it after vacation, then probably in it will make it very difficult to get.
Next week will be very challenging. No problem. The case diary may be sent back at this stage and procured again along with the PM report. The interim bail granted to the petitioner number 1, so extended till the next date of listing. List after the vacation on 15,
Yes.
15/10.
May I have a, can we furnish a copy of, I can have a Xerox.
I have a copy.
You can take no problem.
I will collect from you. Big problem.
If I have pending,
Try to word.
If I find, my lord, I have checked the scan copy of the PCR, my lord. Only 161 section of the victim is available. It is not at all legible.
Oh.
However, I tried to find out there are implicating material against the accused, my lord. Because 164 statement of the victim is not there.
Acha, this case, na, again taken. 164 is not available. 161 is available, but not legible.
Not legible. Now I tried to read what. On that one, implicating materials is there.
Yeah, but it still says not the same thing, not as well. Can they allow him not to that, considering the education lawsuit, that I'm local person at any point of time lawsuit I'll cover.
When was he arrested?
Lawsuit 159. Only because of that, he was out of the job lawsuit, that is the main reason, and refund of that misappropriate money. So this is the main reason.
Any materials indicating that? His instruction that he was dismissed from due to job and then vindictive FIR. Nothing. Oh, so it's a B, right? What is the progress of the investigation? 164 is not recorded.
No, I have only got for the PCR.
Charge sheet has been
Oh,
submitted.
it's a charge sheeted case.
Charge sheet loss.
Perhaps,
Charge sheet also 164 statement.
then perhaps you can, so very fast charge sheet. Sometimes it's possible. Straight cut maybe evidence.
The same thing when Indian lawsuit as per the election made in the FIR lawsuit.
11/9, para 1, 2, 3. In connection with the Jalubari case, the allegation, the FIR dated 5/9/25, lodged by the alleged victim woman herself, is that the accused, who's the owner of the concern in which she works as an accountant, misbehaved with her and committed sexual assault upon her. Sexual assault I cannot do, but others will complete. Don't worry. I got very, very distressed to hear that about Juven's death. It's tremendous loss. If I was working in an office, I would have gone home. We lost Jayanta Hazarika at 34 years, when he was.
19.
I'll have to take some breaks if we work long. Mentally, it's very difficult.
Map resolution. Worship and in this case, worship the
Just a minute. You want me to take this now? We'll go very fast, don't worry. Not as fast as
very
possible.
short worship.
Yeah. Now or fail, let's finish the bails. I will take your matter, don't worry. I'll take every matter. Except, some long matter which cannot be disposed of.
Only 2 minutes lordship time will take. Only just for a lordship and to certificate is lordship.
Don't worry about the time, I'll finish
Lordship.
matters. We have to go fast. Yeah, go ahead.
Lordship, can you come to page number 28, Lordship, impute order, Lordship, passed by the learned fourth below, Lordship, up to court, Lordship. Page number 28, Lordship. And second para, Lordship,
20,
and 22.8, Lordship, 2.8, and extra 6, Lordship. Actually, Lordship, the petitioner's son is juvenile, Lordship, and on that basis, Lordship, he has submitted some documents before the learned court below, Lordship. But court below, Lordship, and did not take into consideration that he is Lordship juvenile. But Lordship, and this order is reflect.
So this was a plea of juvenility.
Lordship. And can you for a moment, page number 24.
Lordship, may I submit?
By
They have filed an application for implement them as a party.
Implement.
Implement, to file an implement matter. So that's either your lordship allow this petition because otherwise your lordship cannot take up this matter because CD is not here. So my lord, they file an application. So they have objection, my lord, even your high lordship here, then my lord, nothing can be done. So my submission before your lordship, my lord, since they file an application for implement them as a party, let them allow, my lord. I have no objection.
my point is that before filing this bail petition by the accused persons, the concerned East Avenue Circle officer has initiated a hearing where the concerned lot bundle,
Circle officer.
concerned lot bundle conveyed us that the original file is missing from the office. So it is necessary to allow us to implement the case and evidence is being tampered. So hence, we are filing this petition.
From Jorhat. Jorhat. Not my additional session just order.
Yes,
Rejection.
exactly.
So you get implemented. File an implementation quickly.
No, they
I
here.
have already filed the petition.
Already filed,
Yes,
yes,
That's the problem.
that, yes, that is probably their fault for, my lord, I don't know whether it is.
We can allow that. No problem.
Yes, ma'am.
But in both the
Good.
cases, I,
Anita Hussain.
I 1067 of 2025. 166 of 2025. The applicant, two applicants are there.
There's a
No, there are two bail petitions, same case, my lord.
I know.
Bail petition.
No, who want to be implemented.
there are 6 informants.
Huh?
6 informants.
6 in front.
6.
The 6 applicants here are stated to be all informants of Azahar dated, FIR dated. Can we save time? FIR dated 6/5,
11/7.
11/7/2025. Giving rise to Jorhat PS case number 350 of 2025, in which the accused petitioners are seeking anticipatory bail system. The applicants are seeking implement as private respondents in this bail petition. Learned Senior Counsel PJ Mount appearing for the respondent slash petitioner of the bail petition. Clearly submits that he has no objection. The IA is allowed and the 6 applicants hereby may be included as respondents in the bail petition AB 2060.
My-
Same order and other.
Yes, ma'am, same order in number. My lord, that probably IA dispose of, my lord.
Oh,
So that there's a technical difficulties there, my lord. Along with the IA, normally it is not done. they have, my lord, filed an objection also. Since it is disposed of, I cannot file reply in a disposed of case. So if they want, my lord, they can file a objection separately, then I can file reply. Otherwise, in the, it will be, if I file, it will not be, my lord, listed along with that, but disposed of file, my lord.
But I has to be disposed of because the prayer is.
Yes, there is to be complete.
I will file it separate, sir.
It is submitted by the learned counsel for the applicant that she would file an objection in the bail petition.
My lord. So let it be after vacation, my lord.
The prayer is lodged. Prayers are disposed of. In the bail petition, we can file this order. This order.
Yes, my lord, let CD call was not received, my lord, already.
I do copy the last one. The case diary is not received. The case diary is not received. Interim is there.
My lord.
Both the cases. The case, the interim, interim order granted by, interim bail granted by order dated 29/8/25, stands extended to the next date of listing. Full stop. The informants filed a interlocutory application seeking implement, which has been allowed by separate order today. Full stop. It is also submitted on their behalf that they would like, they may be permitted to file an bail objection. Prayer is allowed. So you file objection, and then it will come. Same mode. Wait, both the ways, same mode. List after. You suggest. Is it okay for you? My lord. Immediately open. You want it before vacation? We can fix, but very cramped. After vacation.
Before vacation.
Before vacation. I can fix it, but I don't know.
The release
How
or
many
not.
matters will come?
But
Don't know.
Because they are
We can fix it.
UPCD.
We can fix it. You file the objection on Monday, Tuesday, and Thursday, 25. 25. Issue press requisition for CD and this thing. Interim data extent. Good extent. CD cover. Petition by code months.
52.
The charge sheeted case, your lordship, LCO was called for. The petitioner, your lordship, this matter, your lordship, 302 under section. Your lordship will, the petitioners are all named, your lordship, but they were never been arrested, your lordship. Your lordship may kindly come to page 19.
Allegations.
Allegations. In fact, some dispute relating to the land was going on between two groups of people, your lordship. It's a Mofuti, your lordship, and Junai.
Kettle Foster is Mohuti.
Lordship.
Kettle Foster means Mohuti.
Mofuti.
25 people were grievously injured. Division.
Your lordship, they were never been arrested, your lordship, but charge sheet was filed, your lordship. Against them under section 302 along with others, your lordship. Since your lordship, police never arrested them, your lordship.
Never
they are-
acted.
Now summons were issued, your lordship.
Charge sheet must second
Charge sheet submitted on.
attempt to murder.
Yes. Murder. your-
Oh, kill.
26 figure. Now, what role exactly these people played, your lordship, that will be revealed by the case record, your lordship.
The
So
CD.
far as my instruction goes, your lordship, that there is some land dispute going on between these two groups, your lordship, relating to,
And.
and then ultimately this
Market.
happened, your lordship. They say that they were not involved, and police has also not arrested them, your lordship, but charge sheet was submitted. And therefore, they are before this honorable court. Your lordship may kindly peruse the case there, case record, your lordship. And going to the case record, not to the case by stepping to the witness and co-accused. They are fully implicated. They have read the fully but they have done also. All the petitioner's name is there also. As far as statement of the witnesses and co-accused also. One person has died.
One person died, many others sustained injuries. Difficult situation, but at the same time, investigation is also complicated. But the offenses are also very serious. So many people have, according to this medical officer, Bristi, Mona Lisa.
So first is submitted on 31/1/25. They are shown as respondent also. Forming was not taken yet. So next there is 13/10/25 for appearance. So incest to the trial, what's it? At least the trial, what's it, they cannot be understood.
NBW will have to issue. Otherwise, I would have been inclined to that, but the thing is, materials appear to be very serious.
Only your worship respect your worship in my probably is that the investigation is complete.
Yes, that is true. And,
Custodial,
why,
custodial interrogation.
that is not necessary, but you know, if there is, there's allegation that you threatened to kill that person. So only those aspects are lost. However, in murder cases also people get the loss. You have to keep everyone in detention during trial. But
Your worship imposes stringent conditions, your worship will abide by them and cooperate with the trial. Your worship.
yes. Not much time also to think.
I leave it to your worship.
Dr. CD, I have pragmatic movement, special portion of it, the witness statements and the other co-accused statement of it. Because they have fully implicated the these petitioner of it.
Since police could file search sheet, your worship without arresting us, your worship.
There is also one peculiar thing. For serious cases and but no custody, not even custodial examination. Or maybe they absconded right from the beginning.
Yes.
To that effect, your worship, I have made a statement that we have not responded, your worship. We are there, we were there, your worship. And that's why summons were served. Your worship.
Just to. Four 82 bail application on the ENSS 2022. In connection with Jonai PS case number 90 of 2023 under section. Case arose out of an FIR dated 5/7/23 lost by police official was police official, no, sorry, lost by one Bisaram guy. With the allegation that on 4/7/2023. During a meeting organized by the people, the cattle foster at Mumuni Sapori. 6 villagers under the leadership of the named persons therein. Named persons in the FIR attacked cattle foster with sharp weapons, as a result of which as many as 25 people were grievously injured. And Secretary of Jonai Subdivision, Uti, succumb to his injuries. The accused persons are also alleged to have destroyed the buffalo shed and looted money of 1.5 lakhs and threatened to kill the cattle foster. Upon completion of investigation, the charge sheet has been laid against the accused persons herein. The call for case record, PCR, has been received. So as Portable Learned Counsel for the petitioners submit that the allegations are undoubtedly, clearly submits that the allegations are undoubtedly very serious. But the petitioners were never arrested during the investigation. And as charge sheet has been submitted seeking bail at these states. The learned additional PPTP Goswami strongly objects to the bill and submits that the investigation has implicated all these petitioners in a significant manner, and they have been rightly charged. I have perused the narration in the charge sheet. It appears therefrom that as per the medical report of the medical officer, apart from the death of one person, several persons sustained grievous injuries, and several others sustained simple injuries. Considering the matter from the point of gravity of the offense, the incriminating, the gravity of the alleged offenses, the significant incriminating materials against the petitioners, and the consequences, the prima facie consequences of their alleged criminal act resulting in death of one person and injuries to several others. Dash. Perhaps on merits, it would not be a fit case for grant of. It would not be a fit case of it might not be a fit case for grant of anticipatory bail. The petitioners have been indicated as absconders in the charge sheet. The case is at the stage of appearance, stated to be at the stage of appearance and pending for committal. In my considered opinion, not much purpose may be served by keeping the accused persons in detention, provided it can be ensured through stringent conditions that they do not harm the informant, the informant side, any members of the informant side. Refusing bail to the petitioners at this stage might even delay the commencement of the trial. Therefore, despite the grave nature of the materials revealed, looking at the matter from the point of view indicated at I deem it, I'm inclined to allow the bail subject to stringent conditions. According is directed that in the event of arrest of the petitioners in connection with this case, they may be allowed. You suggest stringent conditions. You can suggest. 30,000 money is not a loss. 30,000 with one severity of the like amount each. To the satisfaction of the concerned learned court, SDZ and Juvenile. I will not say that concerned learned court. Following conditions are imposed. I will narrate, you can also suggest. The petitioners shall not abscond. The usual conditions will be there. The petitioners shall not hamper or tamper with evidence. The petitioners shall be available during the trial. The petitioners shall not intimidate harass or try to influence any witnesses. The petitioners shall not in any manner harm, annoy, or harass the informant side, any members of the informant side. The petitioner shall not misuse their liberty to commit any offense. And petitioners shall maintain peace and otherwise cooperate with the process of law. Anything else?
Lordship may say, your lordship, that if they fail to appear before the court on days fixed, your lordship, the court may take your lordship.
This will be lost. The learned additional PP person strongly objects to grant of bail. In case of violation of any or more of the bail conditions, the prosecution or the informant side will be at liberty to move an appropriate application for before this court. Appropriate application for cancellation of the bail.
Lots.
The petition stands allowed and disposed of on the aforesaid terms.
Lots.
The section.
Fox,
Approach the learned trial court for bail and the same shall be considered needless to say in accordance with law and also keeping in mind the stage of the case. That might help. Beyond that, nobody can say that. It's the best part of our institution. Number? Fifteen and 60. No, no.
May I please? Lordship will find FIR is page 10, my lord.
It's page?
Page 10, my lord. It starts from 9, relevant is the page 10, my lord. Here one person has been arrested, my lord, got red-handed while he was loading some sewing machines, my lord, that was stolen, my lord. And he was arrested, my lord, MD Sahidul Islam, my lord. Petitioner before your lordship is the Bubul Rava, my lord.
Regarding item number 60, lordship, and complete at the time of I'm saying this. Rakesh Pamakan and another person, Pankaj, they are in interim. They are definitely is not in the case diary. So where they have appeared before.
Yes, they have appeared, my lord.
That will be reflected on the case diary. Another person, Babul Lava, I think I have to send back the case diary. And up to
Babul Rava has appeared.
Babul Lava is not in interim. Another item number 60. It is in time.
But their statements are not there.
Not here. So
That has to be updated. And Babul Rava?
Babul, he is not in on interim, my lord.
He's not on the check.
He is not.
There are allegations against him. CD has been received. You just see what is there against Babul Rava. Or should I keep it and get the updated one? Take up
the
together.
entire allegation against Babul Lava. Babul Lava has done everything. He is the main person.
So there is an allegation that many theft incidents have taken place in the village.
It is not on the when the,
This particular.
yes, he has to rent up articles for check. When the public held the vehicle, he was cleared away from the place. Sahidul Islam was arrested. Kept and arrested. Yes.
Your good name, please.
Hey, how are you, my lord?
Hey, how are you? Learned counsel.
This bail petition cannot be done bail. He's the main person who told the article for.
The
Everything has already been recorded, my lord.
So it's an AB election.
the allegation in the Azahar dated 2/8/2025. lost by two persons, two informants on behalf of the villagers of Halokal village. Is about theft of sewing machines. And the present petitioner is named in the FIR as being involved in the theft. It is also alleged that the villagers suspect their involvement in different theft incidents which happen in the village. The case diary been received, and on the basis of the same, learned additional PP Goswami submits that most of the incriminating materials are against the present Bubul Rao, who is stated to be the kingpin of this alleged illegal activities. In the given facts and circumstances, I do not find merit in the present anticipatory bill. Same stance return case diary. With regard to the other one, you want the statements?
Yes.
No, they are okay. So
They are going to include.
AB 2019 5960. These persons were granted, the petitioners were granted interim clearance bill on 22/8/2025. Pursuant to which they are stated to have appeared. However, though case diary is received, learned additional PP submits that their statements are still not available, and therefore updated CD may be procured. The CD case diary may be sent back and procured again with the updated investigation, including the statements of these accused petitioners. Their interim bill shall stand extended till the next date of listing. It's on
22/10.
23/10. Online. Huh?
I'm 62, my lord. And there is another item, item number 1 and IP7 also.
To get a detail. Let me write it down.
Sure, my.
Yes, you address your arguments. I will reserve it and give it on Monday. Because I have to see.
My
Oh, no, CD money there. You don't have the CD. right?
CD,
Yeah, it is there. You give it back to. Sorry, actually it got stuck with the CD got stuck with it. Yeah, there. When you do it. It was better. You start your submissions.
my lord.
Can you tell me the item number once?
Item number now is 60, 63, 64, and 65. And 70 also.
And
62, 63, 64,
65 and 70.
70, and 1.
1, 84, 87, and 91.
84, 87, 91.
Item number 1, my lord, that is regular bill, my lord.
One is regular bill.
Regular bill. Item number 1, regular bill. He was arrested on 4, my lord.
The IO has prepared a detailed objection
Yes.
with case laws. So, and try to make out that a case of homicide is it can be inferred from that.
Petitioner is a deputy project manager on the construction of fiber center. This petitioner, item number 1.
Item number
Procedural
1.
Pathak.
Yes, Prasanjit Pathak, my lord. He is a deputy project manager and he is in jail since my 4/9/2025. He was arrested on 4/9, my lord. And my lord, I have already, my lord, we will officially take up item number 1, my lord. Prasanjit Pathak.
Yes, I'm on this one.
My lord, your lordship kindly see, my lord, already, I have already pointed out before your lordship in another earlier occasion also. That status report which was, my lord, submitted here by the disaster management. I have pointed out everything before your lordship, and that disaster management, my lord, satisfied with our precaution taken by us, my lord. And that is, my lord, tally by our page 58, my lord, photograph we have already been annexed here with, my lord. So from the side of the companies, my lord, all precaution has been taken. But some unknown person, my lord, if taken away, my lord, that will be difficult, my lord. On our part.
True, that is true.
But my lord, already they are in jail, my lord, by the why custodial detention, my lord, they are, and for on behalf of company, already 3 persons here in jail.
One is reserved.
Yes, one is reserved and other 2 are, my lord.
Sunday.
Yes, other 2, my lord, they are, one is, my lord, project manager, deputy project manager, and I is, my lord, safety officer. So these are the 3 persons. Others, my lord, this argument, my lord, I already all
Yeah, I remember.
everything, my lord. So my
Notice also.
so that is, my lord, so far is, my lord, item number 1 is concerned, my lord, and so far is the item number 87. 87 is a Kaushik Gogoi.
He is also in custody.
He is also in custody. Since same day, my lord, from 4/9.
Yes, safety is under construction.
Safety also.
My lord. So everything details I have, my lord, annexed, my lord, already argued in the same argument, my lord. Your lordship kindly, my lord, your lordship kindly see, my lord, just those persons who are in jail, my lord. Page 39, my lord, has your lordship got bail application number 3048.
Yes.
Proceed go, page 89, 39, my lord. Page 39. Page 39, my lord. What? These are the 3 persons, my lord, they are in custody, my lord. And in on there are 3 bail applications before your lordship. One is already, my lord, by reserved by your lordship. Other 2 is item number 1 and 86.
Avinash Bhatia is.
Yes,
Yes,
Abhinav
Bhatia.
Bhatia is already
That is-
heard by your lordship, and that is so far is Kaushik and Prasenjit is one. Kaushik is, my lord, item number 87, and so far is, my lord, Prasenjit Pathak is concerned, item number 1.
Arrested on the same day. and
Same day,
forwarded
my
to
lord.
the-
All 3 persons were arrested in same day.
Both the company as the safety officer, but the thing is that everyone should do their duty properly. PWD does not have safety division. It should
My
also-
lord, that I'll
They
not
should also-
go.
Railways
No,
have safety,
overall,
big departments. Aviation safety is very important. But people will follow. Look at the pictures.
So that these are all,
Children,
and
it is also true, which are submitted.
From their side.
It's very foolish if you allow your child to play on the highway, suppose.
that 2-3 year rule.
Huh?
Near the construction site.
And on humanity, another submission I will make, my lord, on humanity and gun, immediately, my lord, company has paid 13 lakhs rupees to him, that has to be, my lord. And my lord, these are, my lord, all, my lord, BA, my lord. Another item number 62. That is, my lord, anticipatory bail application. In that aspect, my lord, 2 were granted interim bail.
Okay, the others are all, these three
Others-
are company official, they are PWD official.
Yes,
Yes.
others are, my lord, no, that item, petitioner number 1 and petitioner number 4. They are one of the director, other is the Ganson. He has no, that's why they are in team. They 2 are in team, 2 are not in team. That is my son.
91 is the assistant engineer civil, PWD department.
63, 64, 65. Lordship, I before little accommodation, Lordship. Lordship, I highly taken up from Monday, Lordship. Mr. He does senior advocate out of station.
Three are in custody of, so
And-
I can say segregate them.
Supply
The-
70.
The custody bills have to be this, I have to write today only. But it will be Monday, have to. But they're also one. But why don't you, well, I'll be good if you can do it, just Same submission, similar submission.
PW officer.
You are better placed also. They are the company safety officer is there.
Yes.
These people can always say what like it is, like it is. And there.
Supply.
And something like this, nobody takes responsibility.
Yeah.
Shifting. That's true. Women.
Supply's 70, 84, 91 also same.
Same. It would have been better. You'll be arguing. Why don't you take some time? After some time, we'll take it. I'm here for something. I cannot compel you, but I'll certainly not compel you. But matter ends, I can dispose it. Isn't? Otherwise, it will linger. And we don't know what kind of list will come on. Like, just you can take some time and then submit after some.
I think it was
Take some instructions if you want.
62 also is a serving as a sector in the civil PW 40
Okay, we'll decide after some time. You take some time. Yes, sir. But I'll be,
But they are inside.
I'll be happy if this conclusion is all the arguments are over and then I can write all the things together. Right?
Okay.
After some time, you let me know.
So they can get 62, 63, 64, 67, 70.
65, 70, 1, 84, 87, 91. 1, 84, 87, 91.
1, 84, 87, and some pending method. Earlier is a DA.
9 bill applications, I think.
Okay, definitely. 84, 87, 91, and 1.
Yes, or the adjournment for which matters, that also has to be.
Taking adjournment on 62, 63, 64,
And
64, 63, 64, 67, 70.
62, 64.
62, 63, 64, 65.
Has to be segregated. So we just not done. Next. 66.
Reason 3 years bail application of it, after Act is 10.
So we have received the case there also in this case, but medical report, specific medical report is not here. Only the medical report is there.
Just before he met them. Worship, can I read the after?
Yeah.
It's 10.
Yes, the FIR.
Yes,
I've read it once.
yes. Sir, I beg to state that the Brahmaputra River has been continuously eroding the riverbank near the border road at so and so. In this regard, the district administration has been carrying out erosion control works day and night. Since the commencement of the work, certain miscreants from the public have been creating nuisance, instigating others, and attempting to hamper the ongoing work. Therefore, police personnel have been deployed round the clock at the site to maintain law and order. On 28, 2025,
SI Samsul Haq Behari was on duty at Kukaranga Erosion Bank from 8 AM to 3 PM. At about 11 AM, he informed the ICKPD outpost regarding tense situation at the site and requested additional force to control law and order. Accordingly, the IC made a GD entry by so-and-so dated so-and-so and deputed me along with the UBC so-and-so to the place of erosion site at so-and-so. Subsequently, at about 11:45 AM, while on duty at Kukaranga Erosion Bank, along with SI so-and-so, the police party was performing lawful duty and trying to disperse a gathering crowd. At that moment, a group of persons led by 3-4 so-called local leaders criminally attacked me, shouted.
No, I don't.
Yes, Lordship, in this case, the FIR name 4 and 5 already arrested. The forwarding report I have already annexed to the petition. And subsequently, they have been released on bail, filed order dated 10/9/2025 by the Lanet Trial Court. Lordship, in that case, that order, kindly see the observation of the Lanet Court below. So,
Page?
Lordship, that was not annexed, I have provided, Lordship. In respect of agent number 4 and 5. Lordship. Lordship, from on going through the CD, Lordship.
Your petitioner is not named in the FIR.
Named, Lordship.
His name.
Serial number 9, Lordship.
But
But I
his-
have taken a plea of LIV, Lordship, on that day he was not the place of offense.
Anyway, so.
Yes. Also, while police party was performing their lawful duty, dispersing the gathering,
That's not
these so-called local
people.
local leaders there, local leaders attack the police personnel and places were several places statements were taken. Lordship. So all are implicated. This petition also, it was one of them. Lordship. And
Investigation is.
victim also implicated. So without going to the injury report also, this person cannot be granted in disciplinary way also. They are taking the law in hand, Lordship. Lordship, kindly see, that is why I provided the order. Perhaps my brother have not gone through.
No, this is there may not be attempt to murder, but this offense is the earlier 353.
Yes, exactly. But
But this is
yes.
attacking the policeman by a group.
Appreciated question. So if anticipated bill cannot be granted.
Is that learned council?
Sure. Lordship, my believe Lordship already I have stated and 2 document I have annexed. Lordship, that is page 13 and 14, Lordship. Lordship, yes, in different district, he went to different district for treatment, Lordship, on same day, Lordship. He was not at all present in the scene, Lordship. And otherwise, Lordship, your Lordship have gone through already the trial court order. There is no progress of investigation at all, Lordship. And no injury report, Lordship, sustained by the victim.
Is that learned council? If you go some. 482 bail application. In connection with South Salman. South Salman case, 103 of the reply. So. 9 named nine persons are named in the FIR. And 20 others implicated without names. The allegation in the gist is that the group of the accused persons can be criminally attacked the police party, obstructed them, and also caused assault. So, Learned Counsel submits that the arrested accused have been granted bail, facing the said relevant order. The learned additional people, some opposing the bail petition submits that the investigation has implicated all these accused persons, including the present petition, and has stated that he was present and involved in the occurrence. Despite the bail granted to the co-accused, I find force in the contention of the learned additional people. Pre-arrest bail application stands on a somewhat different footing. And in view of the materials pointed out at the prosecution, the instant petition is rejected at this stage, return back the case. Then take this, we might need. Next.
68.
No more list.
My please, Lordship. City was called for Lordship. But in this case, also, I am on interim protection, Lordship.
CD is there.
Lordship, I appeared before the IO and my statements were recorded.
CD is available.
So, it will not appear.
Is there not be received?
Search sheet, please. Search sheet, please.
Huh?
Petitioner is in interim.
Charge sheet submitted.
Search sheet.
First data paragraph. No, that's first data paragraph. The first two paragraphs. It is submitted that in the meantime, upon completion of investigation, the charge sheet has been served. Accordingly, the interim bail granted to the this petitioner by order dated 11/9/25 is hereby made absolute, subject to the condition that he shall be available for trial and shall not hamper or tamper with evidence. Allowed and disposed.
Much appreciation.
69, my case diary not received. Next week, any dates?
Other than 24th, my lord, any date.
Okay, no problem. Sorry. Case diary is not received. Case diary is not received. Issue reminder. Stop. 6 on 25.
24. All right.
Adjournment. 88 and 89. 89 was adjourned. 89 and 90. 89 and 88 was adjourned. 89 and yes, tell me.
Lordship, 89 petitioner is the father of a juvenile, Lordship. So interim protection was granted, Lordship.
Before he starts, I'd like to point out now. Well, here in this case, petitioner is in interim. Petitioner is juvenile constitute law. His father has filed this petition, and the petitioner is in the interim protection.
Lordship.
And in this case, the current petition was filed on my lord 2nd of September 2024. Before that, although one of the sections later, in this case, I had found the case diary that section 4 of the Posto Act, victim is 30 minutes. And otherwise, 164 statement, everything is available with the case diary. One person report is also available. And how 164 statement, she has not implicated the accused.
Not included.
Not implicated. The problem is the victim is minor. Regarding other sex acts, 118 and 140, regarding that collectively causing harm. Regarding that I have not found any material. But the problem is that the score is there.
Yeah.
Petitioner is already in interim.
Ah.
Regarding other person, other case in item number 90, also another one person is in interim.
No, sir. That is against.
All are in.
No, that is the same case.
Actually, the informal is not made a party because petition is filed recently, in section postcoded on 28. Because
Sir,
of
that's
that,
what we were discussing.
because of that, informal made a party, notice.
They are also in interim. They are also.
Yes, both the petitions in lawsuit, 89 and 90.
We take it after vacation, extending the entry.
A victim also not at all implicated also.
Because
Difficulty is that victim is.
because the earlier point of time in lawsuit.
No, you are saying that we cannot dispose of because the informant is not there.
Yes.
Procedurally, that
Subsequently, I think POSCO is added in law.
I understand.
But at the time of filing the.
No, it was not there.
POSCO was added already around 28.
Oh, it was already.
But I was not aware of that.
Oh,
So in both the petition, intents of the
the petitioner, whose claimed to be a CICL, was granted interim protection on 9/9/2025. Stop. The Waterford learned additional proof submits that case diary has been submitted. And in her statement recorded before learned JMFC, the girl has not implicated the present petition.
Petitioner's son.
Petitioner's son.
son.
The alleged accused, the accused. So, the accused or CICL. The alleged, so the accused is supposed to be a CICL. The accused supposed to be
Their petitioner is
CICL.
the father.
Supposedly a CICL. Stop. However, the learned prosecution points out that as provisions of the POCSO Act has also been given, therefore perhaps the informant has to be included and given an opportunity to be heard for disposing of this petition. I agree with the said contention. The informant may be included, or he has to file a
I can file an additional evidence to the
the informant may be included and notice issued upon the informed. Interim bail granted by the order 9/9 shall still extended till the next date of listing, fixed on 24th. No issues here. We are just thinking of the procedure.
Yes.
No way to research. 24. And this also, they are on interim.
Yeah, all are, the new lawsuit and according to
The petitioners are on interim bail by the order dated 29/5. I have no question. 29/5/25. Like submission to appear. Prosecution information. Yeah. That's it. The informant has to be. Waited. Here, I think, okay. Interim shall extended till next date of this fixed on. 24.
So both will be tagged.
Sorry, 24/10. 24/10.
24/10 will be tagged together. It's both.
It's pay about the bill petitions. This, both the bill petition, dash AB number so and so shall be tagged together.
May I please, in this case, my lord, I'm not on time, serious control. But FIR is page number 16.
You're on interim?
No, no time.
City not received.
My lord, page number 16, FIR. This is my lord, abandonment of suicide lawsuit. All other co-accused, 3 co-accused has been granted by bail lawsuit.
Oh, the chasing.
Chasing lawsuit. That is the true lawsuit. My lord, the victim whom my lord pistol, started from my lord, my greatest lawsuit.
12 years old.
Where is the true lawsuit?
Inclined. Actually.
In fact, my lord, the
The contention of the FI is my lord questionable, the informant. If it is, my lord, this the incident. He is also a better. Kindly see the my lord, language. Language of that.
Train must have been coming. Only for the light post. Light post.
He saw everything, my lord, the informant.
Light post while people were chasing him. So let us see the case diary. When?
26.
Case diary not yet received. Issue reminder, list on 26/9. 26/9.
Diploma.
26/9. Next. No one is appearing, last dates also.
Earlier also none of you.
Yes, no, it's last 2 dates. Last date adjournment was sought.
Yes.
Thereafter, before that, nobody appears.
After vacation.
None appears on behalf of the petitioner. This is the matter on 15/10.
Yes.
On other lines, on 9/9/2025, also none had appeared for the petition. Now try going.
Order item 71.
Time to see the last order, man. You've taken steps, man, but perhaps, man, steps could not be served.
Okay.
So we'll take these steps, man, upon the respondent.
Okay, yes. You've taken steps, huh?
Yes, yes.
It's not come, not awaited.
No, insufficient address, man. There is an office note.
Office notes. Notice upon the respond number 2, return with remark of insufficient interest. As thus learned counsel undertakes to take fresh steps upon respond number 2.
One liberty, my lord, for seeking adjournment on next date is on 22.
On the last date, the petitioner side was given liberty to seek adjournment before the learned court below on the next date fixed, and it is submitted that such a observation may be made in this order also. Petitioner shall be at liberty to seek adjournment for the learned court below on the next, which is
22/10.
22/10. In the context of pendency of this matter.
Yes. Highly honored.
Please, your lordship, as per last date order.
Service report.
Service report was awaited, lordship. I had inquired about the service report in the registry
Right.
criminal section.
Yeah.
Today, but the registered post tracking report has been received, but
But-
in the office note, it has not been reported.
Achha. Tracking report has been received.
Tracking report has been received of the registered post. I have the tracking report with me. So let the registry
Yes.
be directed
I was-
to place the
It is,
tracking report
submitted
on
that
record.
though not reflected in the office note, the postal tracking regarding completion of service upon respondent number 2 has been received. The registry may place the, may update the office note. Is it?
Lordship, there was an interim on the first day, and let the matter be fixed for admission if possible.
The interim order granted by the order dated 16/12/2024, long time.
Okay.
Shall stand extended till the next date of listing. But whatever it is, we have to fix it after vacation.
Lordship, date may be fixed.
List, on. 15/10. 15/10.
Highly evidence.
Okay. I don't have this submission regarding 62, 63 and 64.
Which
That-
adjournment?
That adjournment.
Uh.
Because they are in interim. The
Mm.
statement are not in the case direction.
Mm.
The statement is required after interim behavior appeared before I or not.
True, true.
So that part also you have. In PA, regarding the PA, regular way. But it can dispose it of.
Yes, BA I will dispose and AB,
The statement may be recorded after the city is called for.
okay, no, all the ABs.
All the items. They all are in the, I think.
Oh, no, all are interim,
All are-
all are interim. BA, I dispose of.
And
And
interim to contribute and after the city case they may be called for.
their statements
Yes.
incorporated. It may be after very soon. Can be after vacation also. But, anyway,
After disposing the regular date, that's it. I will send the custody.
should we try this? Yes. Yes, sir. What is the matter?
Wait, please, your lordship. There are three IAs, lordship, for suspension of sentence under 430.
In this case, as per my, state has today file objection, in this case, so objection, not to pass it to,
No, I have received the objection and I will like to refer lordship. If not an objection, I can give the copy, what have been happened me, lordship. Because
10
five
10
innocent persons are in jail, lordship.
10 years.
10 years, lordship, under 326 and 307. So, if permitted, lordship, just
Yeah,
I would like to refer the request to lordship to take the case of criminal appeal 295/25, the appeal memo for pagination part, lordship, only for referring to the pages only.
But there before can it some other day, today, because I will also have to go through the offer because objection is filed by one of my colleague,
okay.
He intimated me that today he has filed, so probably that is also not a part of the record.
Mm.
Let that objection may come into the record thereafter, you may allow some time today, Then I will also have to go through.
No, you have to give in time. Should I do that? Fix it on another day?
May I finish my
Yeah.
part, lordship? That may be.
Criminal appeal number, sir.
295/25, lordship.
290
I will hardly take 10 to 12 minutes, lordship. I will not take more, lordship.
295.
295, lordship, just for the pagination part, lordship.
Okay.
Here, 5 persons were convicted, lordship, for the offence under 341, 326, 307. The judgment is that they were charged. Before going into other parts, lordship, just gist of the case is that one Rejak and Jamaluddin were assaulted by Abdul Hamid at the direction of Abdul Majid. That is the only FIR. After investigation, police had submitted charge sheet only against Abdul Hamid. Other 8 named FIR accused persons were not sent up. Subsequently, charge has been framed against Abdul Hamid on lordship. This is 23/10/2017.
Against Abdul Hamid only.
Abdul Hamid only by learned assistant session judge Daden. Thereafter, on recording the evidence of the PW1, other 8 accused persons were roped in by invoking the powers under 319.
I see.
So thereafter, other 8 accused persons were examined, including the ammo. And on conclusion of the arguments, learned trial court has convicted the accused persons, lordship, with the sentence for 10 years for the offence under 326 and 307, and for 320/41 also, lordship,
Concurrent sentence.
concurrent. All the accused persons are in jail since 10/7/2025, Lordship.
10/7.
10/7. Abdul Hamid was arrested during investigation, Lordship. During investigation, he was behind the bar for 77 days, from 5/4/16 to 21/6/16. That 77 days, Abdul Hamid extra, Lordship. Now coming on the evidence part, Lordship, just briefly going on, Lordship. If your Lordship go to the page 87 of our appeal memo, Lordship.
Page 87.
The informant. Page 87 of our appeal memo, Lordship. We have given the evidence, copy of evidence.
No, I'm on that page only. I'm on that page only. 87. I'm the informant of the case.
So, may I point out one line, Lordship? Heard that Abdul Hamid beat, attacked Abdul Razak and Jamaluddin. Then he come to the story that I went there, found the accused, but in his cross-examination, Lordship, at page 89, fifth line, Lordship, page 89 of the cross-examination part, Lordship, that he is telling lie in his examination chief has been come out, Lordship, here. I met the victims at Rahman Hospital, Guwahati for the first time. So his examination chief that I went there, saw the victims lying on the road is totally false, Lordship. That part also been corroborated by the victims themselves, Lordship. Now coming on the part of the PW2, Lordship, Abdul Razak, who was one of the injured, at page 92, Lordship, of his evidence, he stated that he sustained backbone injuries, cut injuries on backbone. Then Majid has directed to kill him then and there, admitted in hospital for 14 days. These are the silent aspects of his evidence. None of the victims is present at page 1994, none other than the victim. He admitted in cross, Lordship. Till my reckoning says no one from nearby place came to the place of all the accused persons hails from the same locality. Then coming to the other injured, Jamaluddin, Lordship. He is the other injured of this case as page 99, Lordship. He saw the occurrence in the torchlight. It is the case of this prosecution that Jamaluddin and Razak went together. But if we read the evidence of the Abdul Razak, not a single whisper here there that Jamaluddin was accompanying him. Either he is going ahead, Jamaluddin is following him. Nothing is, this type of evidence is there, Lordship. So reliability of the Jamaluddin's presence is itself doubtful. All other witnesses are hearsay witness, Lordship. The PW4 one Abdul Qadir, he admitted, yes, I am a hearsay. Abdul Hamid, what he stated being relevant, Lordship. I am coming here. At page 106, Lordship. During cross-examination at the last part of page 96, Lordship.
106.
106, Lordship.
That's fine. I
have heard about involvement of accused persons Hamid only.
Oh.
And I did not hear about the other accused persons' involvement. Now coming on the next page, Lordship, 108. Actually, he is the BDP secretary who first informed the police. What is his evidence, Lordship, here? I was at Hussaina Bazaar. Someone informed me about occurrence that Abdul Hamid was beating Riaz at Khalpar. I informed police and then proceeded to the place of occurrence and found no one in the place of occurrence. After about 7 days, accused Abdul Hamid came to me and with me and went to the police station.
This is page
108, Lordship.
cross part, right?
The first part in chief part, Lordship.
Oh, chief.
Second line.
Oh, yes. Yes.
In the first line of the cross part, Lordship.
I've informed him.
At the time, I was watching TV, sitting at election campaign center at Bazaar, and it was a election campaign time. With me, accused person Abdul Majid was also watching TV. This, he has been corroborated this way by PW6 also, Lordship. At page 10110. that Abdul Majid was at the market. In his cross, he stated, I was at Husna Bazar. When I was at Bazar, I heard a marpit. There was a marpit. In cross, second line, Lordship. I did not meet the police at the spot who picked up Rejection on victim. I cannot say. At the Bazar, I was watching TV along with Abdul Majid. In the FIR, Lordship, if you go through the judgment, Lordship, there was that at the direction of Abdul Majid and another, two persons, Abdul Hamid assaulted them. So this part has totally been ruled out, Lordship, that Majid's presence.
Only 6 witnesses, for example. How many witnesses?
No,
for example?
total, I have got 3 other witnesses,
Oh,
Lordship.
no, 9.
PW 7, 8, 9 also there,
It's
Lordship.
not relevant.
I have not somehow missed the
No problem.
7 is a purely hearsay, Lordship. 8 is the IO. And 9 is the medical officer. I am coming to the 9, Lordship, just for one purpose, Lordship. Now coming on this, having said this evidence, Lordship. Now taking to the evidence of the medical officer, Lordship. At page 9, at the PW 9, he has simply stated accused persons are admitted at Rahman Hospital. 2 victims are at Rahman Hospital. He is totally silent regarding backbone injury as stated by the injured. The medical reports, Lordship. Okay. Hey, get out. I have given the medical reports here to issued by Rahman Hospital, Lordship. Some abdominal injuries are there.
Yeah. In the deposition also it is mentioned.
Yes, Lordship.
And there's two.
Whatever in the deposition he has mentioned here, just I have given the copy, Lordship, here.
Yeah.
Now the question, these are the facts of this brief of the facts, Lordship. Now the question of law is that whether simply stating by a medical officer regarding grievous injury will be sufficient. In the legal IPC, there is a specific definition under 320, what is grievous hurt. Not as per the medical jurisprudence, Lordship. Grievous hurt has been defined under 320 IPC, and none of the injuries mentioned in the report, Lordship, covered under the grievous injury
That
part.
we have to make our own determination. Huh? Right? No, and that point only,
No, Lordship.
we do not know the medical, terminology actually, and they do not know our, that 319 earlier. So they give according to their medical assessment of what is grievous and simple. And we apply our own, legal standards. Simple injury, there is no definition legal, only grievous hurt definition is there, right?
So that part is grievous injury.
I'm not.
Lordship, I understand, Lordship. We have to take the definition of grievous injury as per provided under the IPC.
The law, yes.
Not according to the doctor's medical. One concept of 20 days is there, Lordship. So coming on that part, Lordship, I am relying on 2 judgments, Lordship. I have relied on one judgment of Jivan Das. I have given the copies, Lordship, there. Without taking much time, one Bakul Rani Das and one Ejadur Rahman. In all these 3 judgments, Lordship. Now coming the judgment of Jivan Das at page para 5, Lordship.
Supreme Court decision.
No, this is our Guwahati High Court, Lordship. All the 3 High Court judgments belongs to our Guwahati High Court, Lordship. One Jivan Das at para 5, Lordship. One stab wound over abdomen, left side, 5 at omentums exposed, thrown, no vital structure injuries. The prosecution has tried to show that accused person was in hospital as indoor patient, para 7, Lordship, from this date to for more than 20 days, and as such injury was grievous. The observations of this court, Lordship, came at page 9, para 9, Lordship. The question that emerges is whether mere stay in the hospital for 20 days or more is sufficient to attract the provisions of clause 8 of section 320 IPC. And the opinions comes where the medical witness has not stated that injured after remaining under the suffered severe bodily pain or was unable to follow the ordinary pursuits for a period of 20 days or more, clause 8 does not apply. In view of the clear language of the provisions of law, we hold that mere stay or remaining in the hospital for treatment for 20 days or more itself is not sufficient to term the hurt as grievous hurt. In our case, it is 14 days, Lordship. Then in the case of Bakul Rani
And it
Das,
may be the other way around also because as you would agree, sir, that the advancements of medical science, you know, even in many serious cases, you discharge early. But even then, even if you are not staying in hospital for 10 days, it can still be a grievous.
no, for that, there must be it must clause under the 1 to clause 7, Lordship.
Because these laws, you know, because.
Lordship, another judgment I am
And,
relying on
this
the
aspect of, you know, pain also.
Lordship.
Pain also
Lordship.
has undergone a lot of change,
So
right? Severe pain for 20 days. There's so
Just
much-
I want to rely on another judgment, Lordship, Bakul Rani Das. Here, this point, as Lordship has been pointing out, Lordship. Bakul Rani Das at para 12. Though at para 11, Lordship, I'm sorry. Though the medical officer opined that the said injuries being accused caused in respect of ulna, artery, nerve, tendon, which were severely affected were grievous injuries, the type of injury sustained by the injured aforesaid does not fall within the definition of prescribed by section 320 IPC. I am relying on the judgment. Para 12 also
Interesting.
has explained more in this part, Lordship. The medical officer has nowhere opined in the injury sustained by injuries were such nature of a degree which sufficient to endanger life of the injured person. In our case, that is also there, Lordship. Similar view has been formed, Lordship, in the case of Ejadur, Lordship. The third judgment I am relying on. At page 9, Lordship, para 9, the question emerges whether mayor stay in the hospital for 20 days. It has also relied upon the Jivanda judgment, Lordship, and another Supreme Court judgment, Lordship. So far, now, my view,
This will be recorded at the time of hearing also, this.
Lordship,
Will you
that
submit,
makes some.
will you submit?
I have
this?
submitted Lordship judgments. I have given the copies, Lordship.
Will you-
One clip binding,
Oh, this. Okay, I'll keep it here.
Lordship. Now coming on 307 part, Lordship. In our case, accused Hamid allegedly stabbed him, physically assaulted and run away. No one was present there to save. To become an offense under 307, Lordship. Honorable Supreme Court of India in the case of Lordship, I have given the copy. Sagayam versus State of Karnataka, Lordship. It is 2004 SCC 454. At page 6, Lordship. May I refer to page 6, Lordship, of Sagayam. To justify conviction under this section, under section 307 IPC, it is not essential that bodily injury capable of causing death.
No, not necessary. Not at all. Bodily injury is not
Yes,
essential.
Lordship. Here, Lordship, I am highlighting on, it is sufficient in law that if the present an intent coupled with some overact in execution thereof, such act being proximate to crime, intended, and if the attempt has gone so far that it would have been complete, but the extraneous intervention which frustrated it. In our case, Lordship, there was no one, only the injured and the accused as per the prosecution story, no one to interfere. If at all the accused has the intention, which the learned trial court has
Attributed.
attributed to that part for convicting him 307, Lordship, he could have finished. That was no intervention, nothing else. Some overact might be there, Lordship. I am leaving out the ifs and buts in the case of the prosecution, Lordship. So no overact to show that intention to kill. Similar view has been taken by Lordship in Honorable Guwahati High Court, Lordship. I have referred another judgment, Lordship, Ujur Ali. Another judgment at Ujur Ali, Lordship. At paragraph 16, Honorable Guwahati High Court, Lordship. In order to bring home a charge under 307 IPC, may I read, Lordship? Ujur Ali, para 16.
Yeah, go ahead.
In order to bring home a charge under 307 IPC for attempt to commit murder, the prosecution need to prove that accused did any act with such intention that if by the act of the accused death would have been caused, the accused would be liable for the commission of murder under 302 IPC. Therefore, in order to establish the grave charge under 307 IPC, all the ingredients of 302 IPC, except death is required to be proved. It is therefore the intention or knowledge with which the accused did the act
of primary importance and not the gravity of the injury. It is the instant case evidently PW1 inflicted multiple injuries to the victim. It is also discernible from the evidence, more particularly the evidence of PW1, that while he was subjected to assault by the appellant, there was none to intervene. After the occurrence, apparently the appellant left the place, keeping the PW1 injured condition, and thereafter PW1 was shifted to a hospital for treatment. The nature of the injury is the part of the body selected for causing majority of the injuries, and to conduct the appellant that he has left the place after causing injuries clearly suggests that the accused did not have the intention to cause death of the injured. Had the accused harbored any intention to cause death, this line I am upping upon lordship, death of the injured, he could have finished the life of the injured and would not have left the place after inflicting the injuries. This case, facts of this case is similar to our case, lordship. Another point of legal point of lordship is much aware of that part, lordship. Once court invoked the section of 319, then de novo trial is mandatory. Court cannot simply tender the evidence of recorded witnesses there. In this case, that has not been done. PW1 was examined for the charges against PW1 only. Then other 8 accused persons were called. No fresh evidence has been recorded in their case as recorded under 277.
Recall any witness for cross-examination, at least.
Not recall. Here I am referring one judgment, lordship.
Again, examination is.
Yes, mandatory, lordship. It is the judgment of 2002-3 Supreme 566, Sasikant Singh versus Tarkeshwar Singh, lordship. At para 10, lordship, of Sasikant Singh. This is a big legal lacuna, lordship, in this case.
This is the final point of 390.
Para 10, lordship.
Para
10. Sasikant Singh versus Tarkeshwar Singh judgment, lordship. Paragraph 10, lordship. May I read, lordship? It is in the middle part, I am just relieving. The safeguard provided in respect to such person is that proceeding right from the beginning have mandatorily to be commenced afresh, and the witnesses reheard. In short, there have to be a de novo trial against him. The provisions of de novo trial is mandatory. It vitally affects the rights of the person so brought before the court. It would not be sufficient to only tender the witnesses for the cross-examination of such a person.
Stand corrected.
They have to be examined afresh, fresh examination in chief, and not only their
Very clearly.
presentation for the purpose of cross-examination newly added accused is the mandate of 394.
Very clearly written. Very
Lordship.
clearly written.
So, having said on the facts and law on this part, lordship, so for suspension, it is a case of 10 years punishment, lordship, fixed term punishment, lordship. I am relying upon 2 judgments of the Honorable Supreme Court of India regarding the approach of the court
Right.
in deciding this type of matters, lordship. One judgment I am relying upon Bhagawan Rama Sinde at para 2, lordship. Very short judgment, brief
Other
judgment.
day I have come across this.
Bhagawan Rama Sinde, lordship. When a convicted person is sentenced to fixed period of sentence and when the files appeal under the statutory right, suspension of sentence can be considered by the appellate court liberally unless there are exceptional circumstances. I am relying on this, and this judgment has been followed very recently, lordship, in the Somoto case taken by the Honorable Supreme Court of India regarding policy strategy for grant of bail by Honorable Justice A.S. Oak and Justice Ujjal Bhuyan. This has been relied upon at para 13. May I read, lordship?
Page para.
Para 13. The last judgment. There is one more issue which is flagged by the amicus. There are criminal appeals against conviction where sentence of limited duration has been imposed. The learned amicus have invited our attention to the decision of this court in the case of Bhagawan Rama Sinde, which I have referred, Narcotic Control Bureau versus Lakhvinder Singh, and the Ashutosh versus State of Assam. This court has considerably held that when there is a fixed period of sentence, normally the power of suspension of sentence under 389 should be exercised liberally. unless there are exceptional circumstances brought on record. Now, okay, Lordship, I want to point out what should be the consideration, Lordship. According to me, Lordship, therefore, at this stage, when appeal has been filed and appeal has been admitted, the guilt, innocence of the accused should be again revived, Lordship. Normally in trial, it was there, once convicted, though it lost, but once appeal is admitted, Lordship, it should be revived. Then there should be consideration of whether accused, the convicts will abscond, whether any possibility of the convict inflicting of self harm, or the possibility or risk of convict committing any harm or vindictive act against the informant or the victim. In our case, Lordship, during entire trial, the accused, the victims, all the accused persons are on bail, Lordship, except Hamid for 77 days. During trial, he was on bail. During evidence, the victim nowhere stated that we have did any overact to harm them, to derail the trial. We have fully cooperated with the trial, Lordship. We are local persons with any condition, Lordship. We will abide by any condition in the event of grant bail. So sentence should be suspended, Lordship, here in this case. It is a fit case where both legal lacunas are there, evidence are self-contradictory, which in detail we may take up on the appeal hearing, Lordship. But so far, this suspension center, what I have referred, Lordship, only two victims, two injured, they are self-contradicting. So far, their presence. Presence of Majid, which victim is stating, is totally ruled out by the prosecution witnesses. And secondly, our chance, our causing harm to the victim is nowhere, Lordship. And we can assure that during, because appeals are coming up now, 2012, 13, 14 appeals are coming up before learned single bench, Lordship. So there is no surety when the appeals will come for final hearing, Lordship. Another appeal in the appeal of IA for Abdul Majid, Lordship. He is a 72-year-old man, Lordship. We have given several medical documents showing his ailments. He is in Goregaon district jail for last more than 2 years, Lordship, 2 months, Lordship. And his health condition is deteriorated, Lordship. Since 10/7, the convicts are in jail, Lordship. So my humble request, Lordship, the sentences may be suspended. They may be allowed to go with any condition, Lordship. We will abide by any condition, Lordship.
So you will have to file your objection.
Yes, Mother, today matter is fixed for consideration of the IA. But already, Mother, now I'm not counsel appearing on behalf of the applicant already completed the hearing, Mother. Your Lordship may fix that already.
No, I have not concluded.
Today, Mother, I have, state has filed an objection, Mother. That is also not come, Mother.
I get it.
Part of the record.
Another day.
Fix anything.
Another day.
I will let you.
You'll have to complete, learned counsel, escape order, comma, D will, addresses arguments at some length, on the interlocutory application filed, for suspension of sentence and bail for the convict affiliates. Full stop. The learned additional PPP Botakur submits that though an objection has been filed by the prosecution, it has not come on record. So the objection may be brought on record. So we'll have to keep part heard. Yes.
Lordship, maybe on 23,
or next week is very.
on
packed.
24, Lordship.
Immediately after vacation.
No, Lordship, these are 5 widows, one medical, Abdul Majid is 72 years old, Lordship. He is ailing. We have given several medical documents, Lordship. It should be before puja vacation, Lordship. Maybe 24, Lordship, or 25, Lordship. If
The objection will come on record. Can you prepare? Okay. No problem. 24 or 25?
24, Lordship, if possible, Lordship.
List on 24, 9/2025. The matter may be kept as part heard.
Obliged, Lordship. 24, Lordship, please date.
24.
24. Obliged.
24, 9.
Your Lordship, in the morning, I mentioned one
Yes.
to correct,
Oh, correction.
correction, yes, my lord. Lordship, kindly peruse the order, my lord. Item number 9.
Production list.
Production. In this case, my lord, the father of the accused, number 1, is shown as a Ainul Bepari, but he should be Aijol Bepari. That is the correction I want.
In the order, right?
Yes, my lord. Para 3. Page 3, para 3. It may be corrected and read as Aijol Bepari.
In the order, it is mistake.
Yes, my lord. His name is shown in the order, my lord. In his name,
Para?
his father's name. No, my lord. Para 3.
Para 3 case diary is called.
The order dated 5/9/2025, my lord. The bail,
that
in
is
bail
not-
petition, name of the father of the accused is shown, Ainul Bepari. That is, Lordship, kindly peruse the order. He's Fulcon Ali, my lord. Petitioner's name
MD,
is
full call.
Ali,
And MD.
but son of Ainul Bepari, not Ainul Bepari. It should be Aijol Bepari. In the FIR, my lord, it is shown as Aijol Bepari.
But here I'm not finding this actually. Am I reading the right one? Page 8 of your petition?
No, my lord, 3.
No, that is right. This is not the one.
In my petition, my lord, correction petition. I 1071. 1071 I. Okay.
No, that's true.
Your Lordship, yes, Lordship granted bail, my lord.
Yeah.
Yeah.
I know, no, I'll correct it, no problem, but I'm unable to find where my word Ainul paper is mentioned in the order.
No, it is not mentioned in the order.
Oh, it's not mentioned.
Yes, but it is shown as his father name is shown in the order sheet. Order. It is my fault, of course. I'm so sorry.
Oh, no, not. What's your
Yes, my lord, because in translation it is shown as Ainul Bepari. That is why
in page
page 3, my lord.
3.
3, I want that only.
Or in the order, it is not mentioned.
No. Just it is shown as
The applicant was granted bail 2%, right?
there are 2%, but
I just only filed only.
yeah,
for this.
only I.
The
Synchronally,
present application has been filed for rectification of one typographical error in the order dated 15/9/2025
59.
in BA 2846 of 2025,
Yes, ma'am.
whereby accused person MD Fulcon Ali and MD Rahman Ali were granted bail, regular bail.
Yes, regular bail.
It is the Learned Council points out that in the bail petition, the name of the father of
Father of the
Fulcon Ali was mentioned as Ainul Bepari,
Bepari,
whereas his actual name is
Aijol Bepari.
Aijol Bepari.
Yes, ma'am. AIJUL
Aijol Bepari.
Bepari.
Sorry to bold word. Sorry. The applicant seeks correction of the same. Heard prosecution. The said error appears to be a clerical/typographical error in the petition. And same is corrected, thereby allowing this interlocutory application. So now what will you do? This order will be read as part of that
Yes,
bail order.
yes.
This order making the corrections shall be read as part of the bail order dated 15/9/2027. For small mistakes also, we
Yes,
have to
yes, my lord.
undergo that process.
Yes.
You can't help it. Because otherwise they will not, they have records, they will
Yes,
not
yes.
release.
Wait, please, man.
Well, this is done.
My lord, await service report upon the respondent number 2, my lord. My lord would kindly have office note dated 17/18/25. Respondent 2, my lord, I have taken steps, my lord. Service report is still available. Date may kindly be fixed next week.
After vacation.
My lord, next week if it ceases. Any date, my lord, next week. Best
No, because next week only for essential matters,
orders. my lord, will
unavoidable
come-
matters only.
Amicus can be appointed then, my lord. Otherwise, still in limbo. my lord.
Service report upon respond number 2 is still awaited as per office note dated 17/9/2025. List on 26/9 for orders, in the orders code. Deeply over. Anything else?
As per parliament reports, order that makes justice service to the respondent number 2, but he refused to take the notices, my lord. We have also filed affidavit, my lord. Which is still, my lord.
Affidavit has come, yeah. Oh, which one? About this too, criminal. And about side effect. Peruse the last order dated 16/9/2025. It is submitted that in terms of the said order, justice service was resorted to upon respond number 2. And the same is also reflected in 18/9/2000, office note dated 18/9/2025. Affidavit has come on record.
We filed today, your lord.
So file. However, the affidavit filed today has not yet come on record. We'll have to fix another date.
Monday kind of, let's see, worship.
It was delay condonation, right?
Yes, my lord. 295 delays
So
already.
he is in custody.
Custody 4 months already passed, your lordship. Conviction is 6 months, your lordship.
List on the 23 or 22, Monday. 22/9. Last.
High court conviction, my lord. Under section 366 M. Here in this case, my lord, the PW1 is the father, my lord, informant, who is the victim, and he is the villager who support the case, my lord.
This also, I think,
Yes.
will it be possible today? Because no, because I can take, but they may be tired.
Yes. Or order may be passed next week, my lord. 5 years conviction, my lord, as per Supreme Court, my lord.
Will you file objection?
5 years, my lord, only. Only 5 years, my lord. More than. And my lord, in this case, my lord, 5 years may not be a file objection, my lord, because, my lord,
It's up to them. I cannot. Is there any stipulation? In 10 years, you have to. That is your practice. Your
yes, 10 years, 10
prosecution practice directions.
10 years.
So there may be some procedural law also. I don't know.
That is the 10 years objection made by the.
But in sentences below 10 years also they can file, but not essential
No,
as per the principle.
5 years, my lord, as per the Kiran Kumar, my lord, short term, my lord, and already, my lord.
Immediately after vacation. Because I can hear your part and reserve it, but their argument will be there. Their argument will be there. At best, we can take a chance next week, that's why.
Next week, but then 24.
25. But it is very uncertain, so I can fix it. 25, but most probably by default it will go beyond vacation. But we can fix on 25 to take a chance. It may be, we expect that I expect the list to be long for new matters, but it may not be also. There is speculation, more benches may be set up, right? Next roster will come to you. Oh, 25. 25.
20,
Other admission items will adjourn, huh? Not possible. Sorry, I trouble the prosecution.
My pleasure, Lordship.
Only because two reasons I'm saying. Otherwise, I also don't have stamina. So don't think that I'm I have my problems. No, I have no right to bother you. But thing is that vacation is coming, so next week is almost tight, and weekend is there. That is why. That is the thing. Only that is why. Other admission items kindly take adjournment. No need to wait. But you fix the adjournment. Wherever there is interim, the interim will be extended. Don't worry about that. Anything else you want to say? You can say. Just hold on for a minute. Other please. Admission items. Do you want me to go? Like a job. 15, 19 a job. 22 assignment. 2 payments. 16, 17, 18, 21, 20. So kindly make a mention. It will not be practicable that we'll be able to, because I have to sign the orders also.
Can it be fixed next?
It is extremely urgent then only. Otherwise, please adjust after vacation. Which one? Which one? Which one?
22.
22.
Immediately, depending on the.
Yes, no problem.
Winning day of the.
2022, the paucity of time list. You suggested it. You can suggest it. 25 matter, but however, matters. 17, 10. 17, 10, 22.
21,
21.
as their lordship, I appear for the respondent in this case.
Just a minute, sir. Is there any interim order?
No,
We appear on behalf of the respondent in item number 21. There is a stay order operating on behalf of the petition. That is happened, lordship, the respondent filed a complaint case alleging some forgery of documents. And we are not in a position.
Your client. You're the informant.
Yes. And the complainant before the
Yes.
standard trial court. Now, it was at the pre-cognizant stage when the notice was issued to the
Accused.
accused, not as an accused, as an opposite party.
Opposite
Now,
part.
they have challenged the entire proceeding and got a stay order immediately.
Hmm.
So, due to the stay order which is operating, I am unable to pursue with the case. Also. There is some varying forgery which has been.
No, this criminal petitions also, we have to devise a mechanism. Otherwise, many trials will be stalled.
Yes.
And the trial judge will, he is not responsible. Because is there stay, what can he do?
Otherwise, first order, when notice was issued, Garnet, this 14th bench of this honorable court had indicated that stay will be considered only upon notice to the respondent.
Okay.
But on the next date, lordship, without notice being served, stay order was granted by another coordinate bench.
I also,
That is the difficulty on
I
our
may also
part
make
also.
mistake, if it's a mistake.
So if-
Anyway, so, but we are helpless after vacation. But after vacation, we'll try to address it with priority. Arjun, I understand.
Immediately on reopening.
21, paucity of time, however. Mr. Ganguly, learned counsel for the complainant submits that there's urgency in the matter and the petitioners are appealing stay order. Because of the list after vacation on immediately after vacation,
Yes.
first day, 13, 13,
I have appeared on behalf of the respondent.
Respondent number 2.
This has appears for the petition.
That's the time for the petition.
Petition. Okay, no problem.
18. Lordship, immediately after vacation,
20.
18.
Paucity of time, list after vacation. List after vacation on a date, you want a date?
Yes.
14 or 15?
No, let it be a little later than that. 23.
23. What if it would be in the tens?
Huh?
It would be before 20?
The 20 is the holiday, 17.
17.
Earliest.
Just now I have mentioned item number 20. It has been by 17. Maybe 13.
Hardly makes a difference, 2-3 days. We don't know what matters.
Legal counsel is not available.
Okay, 30. Number 22. 13. 13, correct. No, 22. 13.
17,
Highly of that.
17. 25 matter.
17,
16.
16,
Interim contact paucity of time. Spot. This also we can hear another time. Yes.
15,
Just a minute. 15, which one was 15? Petition.
811 of 2023.
We'll adjourn it today.
Can it be taken on 17th of October?
Yeah, no, definitely. After vacation, no problem.
Yes.
That's all. Any interim order? No.
No.
Paucity of time, the good name is?
B. Soren.
This for a learned council request for the petition. Also, it could not be taken. 17 you want?
Yes.
List after vacation on 17th.
Hello.
Just 5 minutes, I'll just 2 minutes. I'll say, it will be 15. It will go 15. So it was very difficult to take it to. Just tell me. So let me see.
Please, my lord, it is a order, the petition has been filed against the order dated 0301, my lord, 2025. 20. Against the order passed by the learned additional CJ, my lord.
Cattle preservation.
Cattle preservation, my lord. Here, I am selling the order by which my Jimma of the vehicle was rejected, my lord. Lordship will find the order at 19. Page number 19, my lord. The last second paragraph from below, my lord. On perusal and hearing, it is deemed that the claim items are necessary for the purpose of trial. Hence, the Jimma petitions are rejected at this stage, my lord. Here, my lord, the vehicle was seized on, my lord, 11/4/2023. Already charge sheet has been filed and the matter is in the stage of trial before a learned court, my lord.
Nowadays it is held that if you keep photographs and all.
Yes, my lord. And from the
Sampling
Ambala,
is
it's very clear, my lord.
But it's not possible. I think you'll have to hear.
I will take a chance, my lord, to get a report for it.
Updated Jima report.
Yes, next.
Yeah, because see, if we have to, as you know, that we have to scrutiny the order passed by the learned court below. It might have been right at that time, but today your Jima may be justified. Right? You get my point. Today you may be entitled. Because at that time the court might have been right. So in a sense, we have to balance both things. Ideally, 482 you have some more power. Revision actually strictly have to see correctness of that order. Yes, but 482, let them take an updated Jima. That might help you also.
The report was earlier called several times from the
Not received.
not received, my lord. Because all for 3 to 4 times, my lord.
Learned counsel, your good name, please.
RB Guhai, my lord. RB Guhai.
RB Guhai, learned counsel. For the petitioner who is aggrieved by rejection of his prayer for interim custody of his vehicle.
My lord.
We seized in the connection with the incident case. The learned additional people, something that he shall take an updated Jima, right? The prayer is allowed. A list. The report may be procured. A list in the admission column on suggested date. 26. Huh? 26. 25. 25. I doubt it will be possible. Can you hold on for some time after vacation?
My lord, once report was called, the IO has already given a report this since the matter has already been in the stage of trial and such has been submitted.
It's not necessary.
So the report is not necessary. And
No, report, no. He said it is not necessary,
My lord, and the IO head himself said, my lord,
that it is not necessary.
it's not necessary because he is not in a stage to furnish the report because all the materials are before the learned trial court.
No, that's why I said, suppose vehicle sometimes can be released with conditions, but after photograph is taken, big things like that, like NDPS sampling.
Lying for the last 2.5 years, my lord, in a field. my
I
lord.
understand.
And even I have not named in a search also, my lord.
Fix it on 16/10, on 16.
My lord, next week, my lord, if possible, my lord,
Okay, take one chance for instance.
my lord.
No, there's no assurance because they are also very tight. It's last day 25.
Try to get it.
25.
Oblige me.
25 minutes. List in admission column on 25/9/25.
Highly obliged, my lord.
I apologize.
I beg your apology, my lord.
We are just assisting you, but you
No.
have to do a lot of.
Now I know, but I got disturbed because of the
Today
news.
also, well, we are also not.
Everyone is disturbed. My wife sent me a message that please tell me that it's a fake news. Just circulating in network.
So we are also not in a.
Because I am interacting, that's why if I am alone, I'll feel depressed.
Oblige, my lord.